Good.
Are you ready, Rich?
Oh, it's on, that clock is
Everybody ready?
fast. Hang on.
In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. If any member has reason to believe this meeting is being held in violation of this act, they should state so at this time. Seeing none, we'll have a pledge of allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mrs. Hutchinson?
Here.
Mr. Murray?
Here.
Mrs. Werner?
Here.
Ms. Hessel? Mr. Ledwin?
Here.
Mrs. Notch?
Here.
Mr. Walsh?
Here.
Mrs. McDade? Here. Mr. Venuto?
Here.
Thank you.
We need a motion to approve the minutes from October 27, 2022. Somebody make a motion.
I'll make a motion.
Second.
Motion by Mrs. Notch, seconded by Mrs. Werner. Mrs. Werner?
Yes.
Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Mr. Walsh?
Yes.
Mrs. McDade? Mr. Murray?
Yes.
Mrs. Hutchinson? Thank you.
Okay, we have a resolution, 111722, that's today, for the Locale Stockton LLC at 5 Stockton Place. We need a motion to approve that resolution.
So moved.
I'll second.
Motion by Mr. Ledwin, seconded by Mr. Murray. Mr. Walsh?
Abstain?
Mrs. Notch?
Yes.
Mr. Ledwin?
Yes.
Mrs. Werner?
Yes.
Mrs. McDade?
Yes.
Mr. Murray?
Yes, and can I comment that I thought the resolution was very well done?
Thank you, sir.
Mrs. Hutchinson?
Yes.
Thank you.
Our first application tonight is Connor and Alex McMahon, 22nd Avenue.
For anyone who's wondering, there's a long line of suspects to punch me in the face, but actually it was my dentist that did this to me today. He said, oops, and blood was everywhere, and that was at 2 o'clock today. So I don't know. I can't imagine. I know it'd be shocking.
Don't tell us who the dentist is.
Hope it's not tinny. This one is another appeal of an HPC decision. I bored you all with a long recitation of the standard of review during our last hearing, for which you just passed a resolution, I believe. So I won't repeat the whole thing, and Mr. Feinberg will probably almost certainly touch upon it, Mr. Galzunas may as well. But this is, we're in our appeal standing now, so it's going to be legal argument. There won't be any new evidence, and these gentlemen are going to base their arguments upon the law and the ordinance and the record below, and then you're going to make a decision based on the standard that was agreed upon by the 3 attorneys that are involved, for the city attorney, the HPC attorney, and myself, standard of arbitrary and capricious, and if there's an error in the decision made by the HPC. And we'll get into that in more detail, I'm sure, as we go, and I'll read it to you at the end if you'd like me to, okay? Anybody have any questions? Okay, was there anyone who's here this week that wasn't here last meeting? No, okay, so I read the whole thing last meeting, so I won't do it now.
I think we're getting used to it.
Yeah.
Looks like a full complement. Good evening, Madam Chair, board members. My name is Ron Galzunas, appearing on behalf of the appellants and homeowners, Connor and Alex McMahon. Mr. McMahon is here in the red shirt behind me. We also have Christina Amy here to just follow along with the proceedings. The property, as you know, is 22nd Avenue, and the appeal this evening is a decision of the HPC to deny the placement of a parking space in the front of the property. A little refresher on the history of the application. This first came up to the HPC on August 16th of 2021, was the hearing and a set of plans that were submitted in application, attendance at the HPC. That application was tabled because the HPC was not happy with adding another floor to the structure. They felt that it would be too big. In response to that, the application was adjourned, it was tabled, and the project was redesigned. Second application and revised plans were submitted. Second application was heard before the HPC on September 20th, 2021. Those plans, which were different than the first ones, were conceptually approved by the HPC. And that appeared in their minutes. each of those plans that was submitted, and on both of those occasions before the HPC, was the parking space that was illustrated on the plan. In the front, to the side, to the left-hand side, immediately adjacent to a shared driveway that went back to a shared garage, which each had one space in it. And to the left of the driveway entrance, Dr. Maslow's house is another parking spot that is in the same space but mirrored, same location but the mirror. After receiving conceptual approval, we then proceeded to obtain the zoning board approval. Now, the board may remember this application because it was a very difficult application. It contained variance relief, which this board takes very seriously and scrutinizes very heavily. And some of that relief was a floor area ratio. There was a lot coverage. And there were also many other factors that were weighed, balanced, considered by the board. The location of the property in close proximity to the beach, where there is an exacerbated parking situation, along with the existing conditions on the property, which included a duplex, a second unit on the top floor, all of which were provided with just one parking space. So the board weighed all those factors. It did its job. It set forth in detail in the resolution its rationale behind granting the variances. It's a uniquely located property that close to the beach, and behind it was dunes and undevelopable area. So the enclosure of the back deck, existing deck in the same footprint, although an increase in floor area ratio, didn't cause anyone any harm. It wasn't visible from the street, and it wouldn't change the view or what anyone was looking at. So the board considered a lot of factors, and in the memorialized resolution, one of those factors were bringing the property into conformance with the zoning ordinance. And in conformance, we mean the duplex was eliminated, and the parking situation was brought up to compliance, 2 spaces for the number of bedrooms that were provided. I believe Dr. Maslow, the neighbor, one of the neighbors, probably one of the people most affected by this, he shared the driveway, he shared the garage. He was satisfied, I recall, with the parking situation and the elimination of the duplex. Shortly thereafter, after 2 times to the HPC, after a trip to the zoning board for a difficult application, after receiving conceptual approval and approval from this board for the variances, and the plans that were before this board were the plans that were before the HPC, they went back to HPC for what was the final approval. So that's the little history of the application. Now, the appeal. Why is this appeal important? You might think, well, it's a parking space. Can't you live without a parking space? Does it really make that much of a big deal? And you know, we could argue like that. But this application has some implications that are much broader than that. It affects the homeowners, yes. It affects all the professionals that appear before this board, architects, attorneys, engineers. It affects this board when those professionals come before this board. And it affects the municipality, the city as a whole, because of the position that the HPC has taken with regard to parking. So how does this affect the homeowner and the applicant? That's probably pretty evident. It's not an easy task. It's very costly to retain an architect to do a design, to come before the HPC, to satisfy the HPC. And I'll sing their praises. They do their job. They do a good job. They work with the architect. They cause redesigns. They've done that. They did that in this case. They had the opportunity on 2 occasions to cause redesigns to the plan, which they did. They actually had them take an entire floor off. It's an expensive, time-consuming process to go through that, and then to go to the zoning board is another layer of expenses and time. So what's they get out of that? They get the conceptual approval out of that to go forward, to go then to the zoning board. So how does it affect professionals, attorneys, architects, engineers who prepare plans and appear before the HPC? Well, they do that, and they all rely upon the HPC's conceptual approval, because as it explained to me by our architect, Miss Christina Amy, this is the process they go through. They design the building, the structure, the bulk, and how the whole thing works together, the placement of windows, which affects the floor layouts. All these things are integral. You move one, it's a jigsaw puzzle. Everything else has to move. So they go through that process, and they take it up to conceptual approval. They get the conceptual approval. At that point, the design professionals are finished with the structural bulk design. They then go before the zoning board or the planning board, and they see if they can get that approved. If they don't get it approved, obviously you're going to have to start over. You're going to have to make a substantive change to come back before the zoning board or eliminate the variances. If you do get approved, then you start your construction plans, which is the details. They don't do construction plans because they're extremely detailed and they cost a lot of money. So you wait till you get your approval to do that. What you've done before that is simply renderings and floor plans. So everybody along the process, and this board, and this is how this board is affected as well, when the architect, as Miss Amy did, and myself come before this board after receiving conceptual approval, the board asks, was this before the HPC? Well, yes, it was, is the response. Were these plans before the HPC? Well, yes, they were. That's the response. The board relies on that. In fact, there's occasions where I've come before this board and it was kind of like, I think we want to hear from HPC first. You're in a zone, we want to know. And that's what we do. We go to HPC first. Why? This board wants HPC's recommendation. They want to know it's okay before you go and you give the variance approval. Everybody along at every juncture relies upon the, quote, conceptual approval. Now, what's involved with final approval? The final approval, as I understand it from the design professionals, the architects, is to come back to HPC where they address subjects such as aesthetics, materials, wood, colors, ornamentation. Nobody's moving around walls or changing designs or layouts when you come back for final approval. It's not the case, because if it was, there are substantive changes. Everybody relied on it. If you change it, that reliance was misplaced and there's things happen. So the position of the HPC that, well, we don't approve parking in the front for buildings in the HPC zone is something that affects the municipality, in the entire municipality. It is a large statement to make because of the large nature of the HPC zone. And it's a blanket approach. It's a categorical approach. It's not will weigh. It's not will balance. It's not will consider each house individually. I wouldn't be here today if I was here to say, let's park a car or cars in front of any of these places on the walls. Obviously, there's a difference. But I'm here today to say parking this car in front of this 1920 Sears kit house, given its location, given all the factors that the zoning board, which are appropriately under the purview of the zoning board, the balancing, those considerations, the parking, that they're appropriately before the zoning board, and the zoning board weighed them. Nothing of that nature happens before the HPC. It's simply, we will not open that door. Now, I'll hand out just a visual reminder of what I've just said about the size and location of the HPC zone. Everybody knows this, but it's something interesting to look at.
What is this? Oh, okay. Let's see, so we can take judicial notice of that. It's not new evidence. Thank you, sir.
Now, why did I just hand you that? I can talk about the HPC zone, we all know it, but you gotta have the map in front of you to see it. I don't know what percentage that is, but it's probably around half of the entire municipality. So around half of the entire municipality, the HPC has taken the position that we will not allow any new parking spaces to be placed in front of any homes, regardless of their location, regardless of their just off the beach, regardless if there's a horrendous parking congestion issue in the neighborhood, regardless if you are eliminating a duplex, regardless if you're bringing the property into conformance with the zoning ordinance. None of those factors matter. I'll get to this point, I'll pull this point back in when I start talking about arbitrary capriciousness and unreasonableness. Because we all know, and Mr. King's advised this board numerous times, at least in my presence, about how the board couldn't say, we don't grant side yard variances. We don't grant rear yard variances. We don't open that door. Imagine that. We know that's not reasonable. That goes to the standard, arbitrary, capricious, reasonable. So that's how it affects the city as a whole. The governing body needs to be aware of this position. This zoning board needs to be aware of this position. So a little bit back to how it affects the applicants. Well, you're pretty far down the road when you learn that, well, you can't have that parking space. So this particular applicant, very unique situation, shared driveway, shared garage, a lot of interaction with Dr. Maslow. There were other options. There were other things that could have been done. At one time, a joint application was considered to come in with Dr. Maslow and talk about what to do with the garage and the parking situation. When this design was finalized, conceptual approval was granted. Those options, those other design alternatives were foregone. If the applicant had known earlier on, let's say even at the first, at the first HPC application, or let's say even at the second HPC application, that we're not going to allow you to have that parking space. Okay. You could have had other design alternatives that could have come up before this board. So is that a reasonable thing to do to the applicant? Is that capricious? Is that arbitrary? And those words have to be understood in the legal context, meaning that there's really no basis for it. So that goes to, I think I heard Mr. King say, What did the HPC make? What mistake? I've heard the word mistake be made. I'm already giving you several. they had ample opportunity to address this. I don't know in how many chances do you get? I don't know what happened. I don't know why I don't know, they didn't see it. They weren't alerted to it. They were I don't know. We don't know. We're not going to know. But we know it was before them. We know it was before them twice. Not only that, but when we had the hearing, and the transcript of the final HPC application bears this out, the HPC had a member in attendance. They weren't alarmed then, and they certainly didn't miss the discussion about the parking. In fact, the HPC itself discussed the parking situation. They looked at it, but they were focused on the clamshells. There's a lot of discussion about clamshells. We know we'll get rid of the clamshells. They're going to put pavers. That was the topic. They were discussing the parking. They had their eyes on it. They were looking at it. And then we went to the zoning board hearing, and a member of the HPC was present. Didn't alert the board, not that that would have been appropriate to do at that time because you're already at the hearing. So that was a third opportunity. It's only when you get to final, the final is the final. It's the last thing in the process for details. So it wasn't the time to address that at the final approval. It should have been sometime before that. It's not good now to take your HPC resolution after you're alerted to the fact that, wait, what happened, and chock it full of justifications about how we can't have parking. So that's not the time to do it. So what problems does that cause now for all applicants coming before this board in the future? When they come before this board and the board asks, do you have conceptual approval? Yes, of course we do. My next question is, well, what does that mean? What does that mean at this juncture? For certain things, I understand. We're not going to hold the HPC to if a committee met or the chairman directed someone or they were given some guidance. I don't think they're bound by that. But there has to be a differentiation of what you're bound by. Are they going to change their mind and say, well, we don't really like that west wing that you've designed? Conceptual approval is not binding on us. The principle here is large. The issue is a parking spot. But what the board decides here tonight applies equally to the parking spot as it does to the future application. There's some pretty big stuff coming up in Cape May. The movie theater, Eustis Mita, I don't know what that is, 5, 6, 7-story building, whatever he winds up with. I'm sure he's not going to want to hear conceptual approval. It wasn't final. So all those sort of factors go into the standard of, was it arbitrary, was it capricious, was it unreasonable? And the legal sense of arbitrary is it's based on discretion and not a ruling or some type of authority. Capriciousness is simply unpredictable, fluctuating, inconsistent, inconstant. I can change my mind at any time. It's not binding on me. Nature of that itself, the statement itself, is capricious. When you come before a board, I come before this board, and we have a secretary, and we have an attorney, and we have an engineer, and we have a vote, and we have a quorum. It's a pretty formal process. And I sort of get the sense when I go through that process and that board votes and that board promulgates a resolution, adopts that resolution, I kind of get the sense that I can rely on that. And I think the architects, the engineers, and the applicants get that sense as well. So I'm just asking the board, It's not just a parking spot. There's a lot more to this. And I'm not belittling how this affects the applicant. This is something that was very important to the applicant. I think that's evident by the fact that I'm here this evening, that it was important, that he has a family, that he needs the spaces, he needs the 2 cars. It's a problem in the neighborhood. The solution of buying a spot out front really isn't too much of a solution when you're in that parking spot's not yours. I mean, that's right next to the beach. So
So, can I ask you a question?
yes, Mr. King.
It goes directly to what you've asked.
Well, I'm almost, Rich, I'm almost.
I thought you were done.
I can wrap up. I mean, look, I can recite the statute, the ordinance, as Mr. King referenced, but when I do, I see that it says that it's an advisory capacity. It advises the zoning board. Zoning board gives the HPC its finality, its teeth, because the zoning board makes our approval condition upon the HPC. It's really the zoning board that makes this the final thing. And the HPC is an advisory capacity only. They issue their conceptual approval, those minutes, that resolution, that goes, and then they can even send somebody to the board to explain themselves if they desired to. We can also look at the zoning ordinance, section 52538D, where it says, an approval by the planning board or zoning board of adjustment, as the case may be, does not relieve the applicant of requirement of obtaining a certificate of appropriateness for those aspects of the change not approved by the application for development. So we take that to mean that what's left over, the HPC is not going to redesign what the zoning board has approved or determined. So the goal of the HPC is an admirable goal. I'm always a champion of the HPC. HPC is why the city looks the way it does. HPC is why the city's preserved as it is. HPC is why the city will continue on to the future in its current configuration, or even better, as things are reconstructed. But this process, in this instance, and the outcome, and the effect that it has on the applicant, the board, the municipality, is flawed. And we're asking the board this evening to correct that. Moving forward, I don't know. Moving forward, the board has to know. We need reliability. We need consistency. We need to know that when we come before this board, we need to be able to say that this is approved. This was before the HPC. Because if it's not, this is what happens. And although this is just a parking space, this can happen again, it can happen again, it can happen again. And it can happen to things that are bigger. Nobody wants that. Nobody wants that flaw in the process. We all want it to work smoothly. There's no problem with going to the HPC. I send people there all the time. Go to the HPC. You got to get their approval on it. And they go. And they want to rely on that outcome, and we want to come here and we want to say, we're approved. We want to be done with it. We don't want to have to appeal. We don't want to have to be here tonight to appeal this. So I'm hoping the board sees that. This is hopefully not something that reoccurs. It's something that's very important to the applicant. It's something that, an issue that the board happened to be deeply involved with, the determination about for the parking, so the board understands all the implications. This wasn't sort of a design feature that, okay, the zoning board's not an expert in what type of windows or what type of ornamentation. Granted, that's true. But in this case, this was something that the board is intimately familiar with. You had a lot of testimony, a lot of evidence, a lot of weighing and balancing of the factors the effect. It's not just the appearance of the HP zone, but, there's other effects and factors that are very broad that affect the entire municipality. And the parking issue is one of them. And it's always one of the most important factors that this board weighs and considers in all applications. So I hope I gave you enough explanation of, and there's plenty of detail in the application that was filed, which bears all of this out. I'm simply just summarizing and pointing out the implications of the documents that have been provided to you. So I'm hoping that you see it our way, and I'd ask you to, I'll say, confirm the resolution that was granted by this board for that additional parking space. Thank you.
Mr. Galzunas, I understand your position is that in the September hearing before the HPC, they gave conceptual approval, which included parking in the front of the building, and that the applicant is entitled to rely upon that. Is that correct?
That's a good.
Okay. When I read the transcript and when I read the materials up here, I couldn't find where they gave conceptual approval for parking in the front of the building. They talked about clamshells and stones, and they talked about actually having the garage back there so somebody could come in and turn around and come back out again. That's what I thought that I read. Now, I may have misapprehended that. And I looked at the drawing, and I couldn't find the parking on the drawing either. So maybe you can enlighten me if you wouldn't mind.
The parking space is depicted on the drawing for both the HPC applications. It's a triangle chevron in the front. That is the standard universal.
Can you reference to us
Yeah, where does
Yeah.
it say
that is?
I'm just saying, that's what they draw for cars.
No, I saw that, but it does say parking on the final drawings that you have there. There is a space that says parking, remove the tree, but I couldn't find it in the earlier
But
ones.
it's not noted on the key anywhere. You wouldn't know this in just looking at this,
Right.
correct? I didn't say it, so that's why I was asking where. I'm seeing that it's here, but where is it indicated that this is a
That's
parking?
the garage. So this is the first application
All right,
here.
okay.
Talk loud so it's heard on the microphone.
Yeah, this is the first application. That's the garage.
Uh-huh.
That's a parking spot.
Yep.
And that's a parking spot there.
Okay. Is this noted on a key? Is there a triangle to the right or to the bottom that would, anyone looking at this as a sheet of paper? I'm just asking because I can't find it. Okay, all right,
It's not on a key.
okay, all right.
What it is the triangle itself designates a parking spot. That's used by every engineer, every architect. It's on every plan. It's required to be on there. If we came in with a garage and said there's 2 spaces in there, we'd be requested to make a revision to show the 2 spaces in the parking spot. That chevron measures, if you scale it, it's a 9 by 18 icon.
Okay, again, I'm sorry, which is the delta? I have the drawing here, and it says crushed stone, but where does it say it's parking?
It doesn't. It just has the triangle chevron here.
So triangle, okay, two parking spaces, but it,
Under, yep,
Rich King just pointed out the zoning chart. 2 parking.
yeah, it's just that, it says it on here, but you can appreciate in looking at this, we
Yeah,
all
it
were
doesn't say-
challenged
right.
with the same thing. So, I appreciate the fact that an architect and an engineer knows that that's the universal symbol, but we're all sitting here looking for it, so, that
and not
point of
only,
clarification.
yeah, not only that, on the final drawings, it does say parking. On the final drawing that was approved here, it says parking, the drawing itself. So that's why I was confused. The initial drawing, I'm not an architect, so I didn't know what you were talking about there, but you're saying it's common knowledge that if they have that symbol, it designates a parking area?
Yes, that is the symbol used to designate a parking spot is that triangle.
Okay, because it also wasn't referenced in the transcript of what the proceedings were. They just talked about crushed stones and,
Right, well,
not that I could find.
I understand, that is, it's a good point. When you, I mean, not every detail about a plan is verbalized at an HPC hearing. They're only going probably to address things they don't like. They don't itemize every design feature or discuss it or specifically authorize it in, I mean, you've seen the minutes. It's just the plan, here it is, and it was granted, it might have a couple more words. A lot of times you just have the minutes as the proof, so to speak, that it went before HPC. Sometimes you have a resolution.
Okay.
But they don't go through and approve every design aspect of a set of plans.
Okay, it was an interesting comment that you had, that they only address things they don't like, because they did address parking in the 2 subsequent hearings. They addressed it, they refused, they said that they would not approve parking. They specifically mentioned that in the transcripts and their resolution.
Only the third time for the final. The first time, the first HPC hearing, they did not. The second HPC hearing, they did not. We went to the zoning and then back to HPC for final approval. It was only at the end of the final approval where they brought up the parking spot. And it was brought up by the member who was in attendance at the zoning board hearing, and his concern, if I recall, was the cedar tree that was located in that area. And his question that brought the subject up was, what are you doing with the cedar tree? How are you putting in the parking space and with the cedar tree? And then I believe the chairman then started talking about the parking spot. So it literally, at the end of the process, did the chairman identify the parking as an issue?
Well, I don't think, I mean, again, I agree with Mr. Murray that I did not see that anything was delineated earlier in the transcript. I appreciate that sometimes it's not always in that detail. But when you went to the third time to HPC after having come to zoning, there were some substantial changes made, even noted by your architect, on the design of the building, and which is included in the transcript. So you were really going for a final approval, and normally during final approval, design features are discussed, and HPC, at least in the minutes that I've seen, goes through materials to make sure that things are delineated for the minutes. And the design standards that HPC publicizes, a publication in the city, it says design standards, paved driveways and off-street parking. So this is something that should be known by an architect or an engineer that's being engaged by someone for an HPC-related property. This is not new information. This is something that's in a city publication and adopted intentionally and purposely to make sure that people are aware of what the standards are. And it's in a booklet that says design standards. So this is part of the design standards that the HPC has put forth for people to be aware of when they are building or renovating within the city of Cape May.
And she says that it's hard to do. I just want to point out, in the first hearing on page 5, it sounds like that there's a discussion where Miss Amy says that it's hard to turn, there isn't space to turn around in the back. And that they're reducing the garage. So it sounds like it was discussed, but all right. So here's the difficulty and the question. I had 2 questions I wanted to ask you, Mr. Galzunas. The first one has sort of been addressed, which is, you read from our ordinance, but our ordinance tracks the statute, and it says that the HPC is dealing with aspects that were not determined by approval of an application for development by a municipal agency. So, in this case, it seems like this municipal agency did approve the parking as it appears on the approved plan. So now, after it's been approved by this board, it's now back in the HPC being altered, and I'm just not clear that the statute contemplates that. And you
Well,
get to that argument, but it's
well-
supposed to be, once we've decided it, it's not supposed to be an HPC matter, as I understand that statute.
It sounds like what you're arguing is favorable to the applicant, that once it's
I'm giving
decided
you
by...
We call it a softball.
Yeah, no, I agree. Look, like I said, I indicated, I'm not quite certain how this transpired. I know that it did. I know that that plan was before them, and accompanying with that plan were photographs of the front of the house. You know, the first application was, I think it was Zoom. You know, sometimes the applications before the HPC move pretty quickly. You know, they're not going through and scrutinizing every little detail. I think if they like it, you really don't probably hear. They might say, I like your plan, but you're not having it. It's not like a zoning board where you're going through each and every is the zoning chart that contains all of the criteria and measuring and comparing against each of the criteria. To the lady's point of, well, here's our design guidelines. Well, did the HPC ever go paragraph through that extremely large document and check the box? And the process just doesn't happen like that. Maybe it should. Maybe it should be a little more formalized.
My view is that parking, I mean, this is just, the idea of conceptual approval, I think mostly, in my view, is to eliminate future variances. That you're supposed to get an idea of the big, important stuff, so that when you come here, all the variances, if you're gonna move ceilings, or tell them, don't put that wing there, or all that stuff, that's supposed to eliminate the things that are gonna mess up the process, so that when you go to the zoning board, you get all the variances you need. Okay, then when you go back, you can do railings and shutters and all that stuff.
Yes.
But the idea of conceptual is you can come here with some assurance that what we're looking at is going to be structurally okay when it gets back down there, so we don't have this problem. Because I need everyone to understand this, and this was my second question, but I'm just gonna come out and say it. If you grant this appeal, you are voiding their approval, because their prior approval did not require a parking variance, because they had 2 parking spaces. If you grant this appeal, you're bringing them down to 1 parking space, and they will need to comply, they will need to get an entirely new approval, because there was 1 vote, and I'm not even sure, I have some concerns about notice on this too, because, remember, they mentioned Dr. Maslow, but it's not just Dr. Maslow, it's everyone who appeared. They came here, they complained about parking in that area. You approved this. One of the main reasons you approved it is that it had compliant parking. That was a major point of discussion. Okay, there were 2 parking spaces. And now if you say, well, we're gonna support the HPC's removal of a parking space, you now don't have 2 spaces. It changes Craig's zoning chart. It's gonna be a non-conforming next to parking. And that prior approval, you can't do what they do what they want to do. They don't have an approval anymore, because now they need to have 2 spaces. So, you know, their fallback is, well, we want to have 1 space, but I don't view it that way. I view it as they don't have their old approval. And that's what conceptual is supposed to eliminate. So in my view, if the HPC, this is our 3rd appeal relating to parking in the front yard. Okay? So the HPC really needs to, in conceptual, that's one of the things they should be looking at is parking. Apparently it's very important to them. This is our 3rd front yard appeal. The first one may have predated some of you, but it was on Elmira. Then we had the one on Beach, and I may be missing another one, but I mean, this is a big deal. And to have an approval of this board get blown up because we're doing parking, eliminating parking spots on final approval that wasn't, you know, that I know there's some question about that V and if that's parking, but they talk about not being able to turn around. They have 2 Vs, which it's 2 parking spaces. Where are they? I mean, that's a question that should be addressed. So I'm very concerned, and I want the board to understand that in my legal opinion is that if you eliminate a parking space, and you may do it, I'm not saying don't do it. I just want you to understand that it's not simply a matter of them now saying, okay, we have 1 less parking space. They are now non-compliant with the zoning ordinance. Their prior approval required compliant parking. there has not been a new notice issued for that, changing that old approval. So everybody who had notice of that and came to that hearing and said, okay, they have 2 parking spaces, and then left that meeting thinking that that's over, we published a resolution that said it. So it's a very big deal to change that. So I really want you to give that, understand that as you make your decision. You're gonna apply the standards and all, I get that. But this is something that the HPC, it's important to them, they should have noticed it. In my opinion, that's what conceptual approval's for. And if we're gonna do it, you're blowing up the approval. So you can still do it, and that's up to you. I'm not a voting member, but I want you to understand what I view as the implications to that approval if we eliminate a parking space. Do you understand that? So go ahead and do your thing, but
I
that's.
think so again, but the bottom line is we are deciding whether or not the actions of the HPC were arbitrary, capricious, and unreasonable, right?
That's right.
Okay, so we look at these things, we look at everything in toto on the record.
Absolutely.
And whatever they did, we have to determine whether or not, in our view, okay, the standard is whether it was arbitrary, capricious, or unreasonable. So I guess, I can see, for example, I think Mr. Galzunas raised the fact that, well, the board, the HPC said, we always deny this, okay? Is that an arbitrary decision on the part of the HPC that we always deny parking in front of the house? Okay, that's something that we can look at, I think. Isn't that correct? Because I think that I have the transcript from the last, resolution here before the HPC that, I think the chairman said something like that. We never grant these, and I think that.
That's not what he said. It says, we have not approved front parking in applications that came made for obvious reasons, because people, so, I don't know that he says we'll never do it. He just says we haven't approved it because there weren't cars. So I just want to make sure we stick him with exactly what he said.
No, yeah, you're exactly right. But again, I mean, right now, I mean, the substance of the matter is there's 2 competing interests here.
Yep.
There's the interest of the historic preservation of our beautiful town, and there's also the interest of the community of parking. We're dying from, lack of parking space, so I guess that can enter into our thought process as well,
Yep,
I think.
absolutely.
Okay, enough from me.
We should hear from Mr. Feinberg.
Yes, absolutely, sorry.
Oh, hello, Mr. Feinberg.
Hello.
Would you like to speak? Thank you.
Yeah,
Do you have, you have one microphone.
can you hear me all right?
Yes.
Robert Feinberg, representing the Historic Preservation Commission, solicitor.
Excuse me, Mr. Feinberg, do you have your mic on?
Yeah,
Okay, thank you.
another one on.
Thank you. Great,
Can you hear me now?
thank you, yes.
All right. First of all, the chairman, Warren Copeland, wanted me to express his regret not being able to be here tonight. He's in Philadelphia, pretty urgent business, and wasn't able to make it back. He didn't want you to construe that as he doesn't have an interest. He very much has an interest in this application, but that's why he isn't here. I hardly know where to begin. I think what we heard from council was brilliant argument, but I don't think we heard a lot about the detail of what occurred, what really occurred, and what is in the record. And as you know, when you consider these things, you consider them on the record. So it's important to look at the detail, really, that is in the record, and we started to get some concern about that, and I think it's valid, and we'll talk a little bit more about that. Also, I think there's some glaring disregard of our zoning ordinance and what that zoning ordinance says here. And I can see why it would not be mentioned, but I think it should be. I'm just gonna read one section here right now, and I'll get back to it. But I'm gonna start off with this because this is probably one of the most important laws that we have on the book. It's in our zoning ordinance, chapter 525, and it is section 37, subsection D, which deals specifically with informational meetings and conceptual review. This has not been stated yet this evening. This section says, and I quote, "Neither the applicant nor the commission shall be bound by any informational meeting or conceptual review." The applicant is not bound by what happens. The commission isn't bound by what happens. And everybody should know that, particularly the professionals, the architects, the attorneys. So to say that you are relying on what happened before the HPC on conceptual review, well, shame on you, because that's not what the law says, and you should know that, and I'm sure they do. This is our zoning ordinance. They've read it hundreds of times. They shouldn't be bound by what happens in conceptual review for the very good reason that when it comes before the HPC for final review, after a permit has been applied for, bear in mind, when you go to conceptual review, you haven't applied for a building permit. You've applied to a development board, the zoning board or the planning board for development. You haven't applied for a construction permit. You only apply for a construction permit when you're ready to build. I think, as was said, you've got renderings, you've got very brief plans before conceptual. But when you go to final, you have a set of architectural plans, you've got final plans, you've got sealed plans, which can vary a great deal. And a part of that variance can be because of what you guys do when it comes before you. You change the configuration, it's not an uncommon thing of the building, and that's why the HPC doesn't even consider a final until it's been before you and they see the final configuration. So no one should be relying, and no one should be saying to you, oh, we spent all this money, we're relying on this. We got conceptual, and I'll argue that in a minute, whether they really did. But they say we got conceptual, they should be bound by it. That's not what the zoning ordinance says. Black and white. I think that's very important. I may get back to that in a moment. But first, as I say, I think the way to approach this is to look at the record in some detail so you fully understand it and can fully appreciate in context what the record is. And also to fully understand that's not the only provision of the zoning ordinance that wasn't referred to. You should understand that also. And let me also say this right up front. You got a packet, a very good detailed packet from Mr. Gelzunas a little while ago, and he gave you all the documents he thought were pertinent and for you to review for tonight. Including in this packet was the HPC final resolution. But what was not attached to that resolution, and it was at the time the HPC acted on it, was the standard, the design standard. And that design standard is taken from the design standard book. It was not supplied to you. So you didn't have the reference that was made in the resolution, yes, to what the language is. I supplied that to you earlier this week. It didn't come from Mr. Gelzunas. Now, I'm not, good man, I'm not saying that wasn't a simple error, secretarial. But the fact is, you didn't have it until this week. And that's critical because that design standard is what the HPC relied upon and has to rely upon, legally has to rely upon. If they don't do what that design standard says, they've done something unlawful, and they can't do that. So if I can just take a minute and go through some of the exhibits that Mr. Gelzunas supplied you in a little more detail, not really argumentative, but let's see what they are. His Exhibit A, that was the HPC application. It's dated August 3rd, 2001. The very first Exhibit A, and you have his application. There's the first page of the application. He's looking for conceptual. And what does he say he's looking for? Elevate existing house to build an addition beneath, replace rear decks, update garage, and refresh exteriors. Doesn't say a word about parking, okay? The material list that comes with all, a survey. This is a historic survey, not a meets and bounds survey. And this survey indicates that this particular property is rated contributing. And I think, as you all know, properties within the historic district have 3 grades. One is key, it's the most important historical property there. 2 is contributing, it's 1 level below key, it's important. Third is not rated. And when you have a non-rated property, you can do pretty much everything you want to it. It does come before the HPC, but the standards of review are much lessened. Contributing property is important. So when that comes before the HPC and they see it's a contributing property, yes, they do give it particular attention because they don't want to lose it as a contributing property. It's important to the district. The minutes of that meeting. No, let me reference something else. There were drawings attached, and I think you've looked at these already. The drawing that you see that accompanied that application is kind of bare bones. It does have a triangle on it, lower left-hand corner. It doesn't reference parking, doesn't give dimensions of the parking. It talks about a crushed stone driveway, and that's the only reference to parking that was seen by the HPC at that time. It wasn't brought to the HPC's attention that there was going to be final parking, at least, in that section. The minutes that were attached of that meeting, again, show absolutely no discussion of a parking space. The plans were reviewed, and the comment was made by the HPC at that time, well, this plan, adding a third floor to this contributing property, could jeopardize the historic integrity of that building, and we don't want to do that. So they did go back and they revised the plans to meet that concern. So now you have Exhibit B, which is the revised plans submitted to the HPC, which eliminated that third floor. That was a concern of the commission. Again, the application that was submitted for that second meeting, what's that for? Conceptual. Open porch, build addition to rear, not the third floor now, to rear. Reduce the garage, refresh exteriors, repair, replace foundation, not raising building. Now, here's their second chance to bring it to the attention of the HPC. We want a parking space in the front of the building. It's not on the application. The plan that they submitted in support of this revised plan with regard to that parking spot didn't change. You still have that triangle. You still have no reference to parking. You still have no dimensions to a parking space. Nothing to highlight the attention of the HPC that we're going to put a parking spot in front of the building in spite of what your design standards say. Then comes Exhibit C. Exhibit C is a transcript of the meeting of September 20, 2021. Again, the conceptual review meeting. At page 5 of that transcript, line 8 to 20 is the only reference in that meeting to parking. And it says, and this is Miss Amy, we're required by zoning to accommodate 2 full-size parking spaces. Fine. Where are they going to go?
Where did you think they were going to go?
Where did I think they were going to
Where
go?
did the board think they were going?
There's no reference to that.
But like, well, isn't that something that they would, to verify that their design standards being complied with, they wouldn't look to see, well, where is the parking going?
If there's going to be an assumption made, I think the assumption would be you're going to comply with the design standards where those parking spaces are going to go. That would be the assumption. Certainly, it was not highlighted by the applicant.
Well, they put 2 triangles. I mean, I guess what I'm trying to figure out is, are you saying that the record in the conceptual approval demonstrates that the board didn't know where the parking was, or that they thought it was in the back? or that no one thought of it at all. There was just the concept of parking didn't cross anyone's mind. So I'm trying to,
I'm not going to speculate about what they individually were thinking. All I can tell you is what the record shows. And what the record shows is a triangle up front, a statement that they know they need 2 parking spaces. And they also know, everybody knows, that it has to go back with final plans to the HPC. That everybody does know. In fact, at that hearing, page 16, lines 6 to 9, the chairman says, and it's conceptual. Mr. Testa, yes, it's going to come back for another look anyway. Amy, right. Everybody understood that this was an informational, this is a conceptual meeting, this is not final, it's going back to the board. That's what they do.
go back to what you said. You said that they talked about, here's what the quote is from page 5, and this is a board member brought this up, so I just want to make sure it's clear in the record what he was referring to. And this is at the conceptual meeting, I think, and it says this is Christina Amy testifying. The other thing I haven't mentioned is the garage itself. We're required by zoning to accommodate 2 full-size parking spaces. She does say that, but then she says, and the access for those spaces, if they were to turn, would have to be able to turn back around. Due to the shallowness of this lot overall, we don't have the turnaround space to park in the back. So it sounds to me like she's testifying that the parking can't go in the back.
Sounds to me like she's setting out grounds for a variance application.
Well,
Hardship.
That's my point. But then they come to the variance application, and a member is here, and the board, as you know, the HPC is permitted to testify at any application, offer its advice, and nothing happens, and they approve the project with the parking in the front. So that's why I'm asking if the board thought the parking was in the back. Because if the presumption is they're going to comply with the ordinance, but then she says we can't park in the back, then to me, that means the HPC knew that they weren't parking in the back, that they weren't going to comply by putting 2 spaces in the back. And then they came here and spent several $1,000s to get an approval with the parking in the front. And that seems like, I'm trying to understand if the HPC didn't think about parking, or were told that it couldn't go in the back, but didn't do anything the first time they had it. I'm trying to understand what they were doing the first time.
What they were doing was they were hearing an application conceptually. That's what they were asked to review. And 99% of that had to do with modifications to the building. Thousands of dollars was spent with the applicant's attorney and architect and revising plans to deal with the changes to the building. The parking spot appears, to me, if you want my opinion, as very much of an afterthought. A little triangle in the corner of the plan, how much did that cost?
It wasn't an afterthought. It seems like she talked about it couldn't go in the back, and then they had plans with the triangle, one in the front and one in the garage. So I'm just,
On the plan also, on both of the plans, the iterations of the plans, there's a zoning table on there.
Yeah.
And it has number of parking spaces, and it shows what's required. And then it says what's existing, 1 space, and then it says proposed conditions, 2 spaces. You know,
I'm confused because
Are you
I thought
referring
that
to the application here or HPC?
You're referring to the exhibits in Mr. Galzunis's package. So you're talking about the triangle, but there's also a zoning table below, at the bottom of those plans, that show on the last line of that table, the number of parking spaces that are required, the number that exist, and the number that are proposed. So it's quite clear on those plans that there's 2 proposed.
But I'm confused because this is the minutes from the September 2021, and that's when the architect is indicating, oh, by the way, I have to mention now that we need 2 parking spaces. So how did she know that all the way back here? I mean, I'm a little confused as to
I'm
why
just
that-
telling you what's on
yeah.
that plan.
No, I agree, but
I have a question. I want to get that in my.
yeah, so on page 5 of the meeting minutes from the September meeting,
Right.
she brings up, oh, the other thing I have to mention is the garage itself, and we're required by zoning to accommodate 2 full parking spots. And at that point is making note of the fact that they can't do the turnaround in the back. So if they presented a plan in the very beginning with parking in the front and the back. Why was it never brought up before? I'm a little confused as to why.
Brought up by whom? She said.
The architect,
But she's the one who said at the conceptual meeting, we can't park in the
but
back.
the September conceptual meeting. The Exhibit A is from what meeting?
Exhibit A is from the very first meeting.
August 3.
Well, that's the date of the
Oh, okay, all right.
plan.
All right, wait a minute.
Am I correct that Exhibit C is the
It says
conceptual
July,
meeting
so I
with the
can't tell
HPC?
which date this
I'm
is.
sorry, Rich. what-
Is Exhibit C to your packet, the conceptual meeting with the HPC?
The first one or the second?
September 20, 2021 meeting?
It's September 20th, 2021. That's before you get to the zoning board.
Correct. The first meeting would have been in July 15th.
Right, the first meeting is where they
August.
say you got to chop off the top floor, then you come
Right.
back in September, and this is the conceptual meeting. And that's where Ms. Amy says we don't have room in the back, and there's a set of plans that has a triangle in the front and a triangle in front of the garage.
Okay, so can you just clarify, Rich, for me? Exhibit A, plans,
Yes,
from which meeting are these from? Because there's triangles in the front and back. I'm just trying
that's the
to,
first, that was part of the conceptual approval record.
July or September? I'm sorry to be so
Probably-
exacting, but,
Well, I don't want to answer, let them answer. Is this plan, that's
Okay.
Exhibit A, Ron, in your packet, is that from the, well, I'm in B, so
A is the first one, the first.
First conceptual.
it's on the
First
it's on the first
conceptual.
conceptual, it's on the second conceptual.
And that was reviewed, and that was tabled. The plan was revised, the application was resubmitted for the September 7th application.
so maybe I should ask the question in a different way. The first Exhibit A, plans, those were consistently the same plans with parking for Exhibit A, B, and C.
The parking never.
Never changed,
The
I heard.
parking never changed.
Okay, all right.
It was always in the zoning conformance chart. and
That's my point,
triangle
Rich.
Icon.
The third time, there's more detail.
Understood.
Okay.
I just, that she's bringing it up here as a change with the garage in the third
That's in
time.
conceptual. No, that's not the third time. Exhibit B, where you're circling and you're rubbing your hand on something, what are you?
I don't think,
Exhibit C.
Okay, Exhibit
the
C
minutes.
is the transcript
Been on
to
the
the
plan.
conceptual approval.
Okay.
So before they came to the zoning board,
Mm-hmm.
that's Christine Amy testifying that you can't park in the back because there's not enough room. I think
It
that's
says we're
testimony.
required by zoning, so it's not the zoning board, it's just by zoning ordinance.
Right, yes.
Okay.
She hasn't been to the zoning board yet.
Fine, okay. But she's saying zoning, I thought it was the board. Okay.
She says that you can't park back there because you can't turn around, but if you read a little further down, it says we are proposing to reduce the garage, and we will rebuild the roof for neighbors ultimately. I believe there would be a separate application once all these details are coordinated.
So the
So it's-
implication that I read into it, she removed half the garage, so it gives you room to turn around.
Or another parking
The way I
space,
look
yeah.
at it. But, I mean, that's one way of looking at it. But the other thing is, the very first one on Exhibit A, there's a motion made by Mr. Testa for conceptual improvement of the design of the structure, et cetera, subject to a change in design of parking to be moved to the rear as much as possible and not in the front. You said that early on. It's here, it was part of your Exhibit A, the last
Right,
page.
but you were first talking about a design proposal that was abandoned as a result of obtaining the conceptual approval for the parking spot in the front.
Which is the,
That's E, that's
Page
when
4.
they go back for final, I'm pretty certain.
well, that's not what he said for Exhibit A.
Right, so, right,
Let's get that
but
clarified.
you're,
Hold on,
right,
Mr.
you're,
President. Let's get
yeah.
that clarified. That's an important thing. I want to make sure we have the dates right.
Where is it?
He's pointing to minutes. And those minutes say,
which exhibit?
Exhibit A, the last page of your Exhibit A. At the very top, where it says, motion made by Mr. Testa.
Last page of Exhibit A, right, so that's the minutes that turned down the first application.
Yeah, that's the first one, right?
Right, that turned it down. Commissioners felt it was not possible to approve the plan without threatening the city's national historic landmark status. And then the plans were revised to address that and sent in, and the same parking configuration was presented. But to go back to your earlier point, sir, you were talking about the way you were reading into this, that one of the proposals, one of the design concepts was to demolish a portion of the garage. There were many design concepts discussed, but all of those were abandoned, jettisoned, when the applicant received conceptual approval for the spot in the front. That's one of the problems here. That's one of the detrimental reliance aspects of this, is that, yes, sir, you're correct, there were other alternatives. And because of the conceptual reliance on the conceptual approval, they were not pursued.
Wait a second, this might be a red herring, I got to check something. I think this isn't for 22nd Avenue. Can you guys focus on this for a second? It's important. Go to that thing that he just pointed to, the last page of Exhibit A. Because he's read this into the record, and now I got to make sure that.
I think you're right, Mr. King.
What was just read, I don't think this relates to 22nd Avenue. This is whatever application was before it, because he's kind of worked their way down. 'Cause
Because then it goes right there. It says Rushlow, 22nd Avenue. This has nothing to do with
Right.
the hero.
Or does it? See,
No, the motion for the 22nd Avenue is in bold below.
Is below.
Right.
This has
Right.
nothing to do.
This doesn't have to do with this application up here.
They're separated by the dotted lines.
Yes, do you see what he's?
I saw what he read, yeah.
Because this makes it sound like that they talked about moving it to the back away from the front in your application, but I think that top part is an artifact of an orphan from the prior page. Is anyone?
No, you're correct.
Yeah, that's
You're
nothing to
correct.
do with this.
So that statement that you had in there does not apply to this particular issue?
he had this here to show
No,
you what
because
happened.
this is this, this is this. This is this, and this is this. So this applies to something that we don't have the previous page for.
But it has nothing to do with what we're talking about tonight.
Well, I want to make sure that that's correct.
That's what I'm trying to make sure
Because it's
of.
part of his brief that says that it is.
No, I don't believe I
He's
referenced
just giving me
that.
that for this. He's giving it for that. He just copied the whole page.
Okay, okay.
Yeah, I didn't.
That's confusing, but
Okay.
that'd be critically important.
Yeah, I just want to make sure
Yeah.
that it has nothing to do with this particular, okay.
If you look down at the next one, you can see where it's designated, the line is there.
Yeah, those folks got approved.
But it does say that whatever that application was, it does say that they want the parking moved as far back as possible, not in the front.
Yeah, I'm just,
Just has
hey,
nothing
just
to do.
Has nothing to do with it.
ignore that. Has nothing, it's not in this
Shouldn't even
application.
be discussed. It has nothing to do with it.
I'm ready to move on. I'm now looking at Exhibit D, I'm up to that, and that's the zoning board resolution. It's Resolution 0324-2022:2, and that's dated March 24, 22. It's interesting, this discussion about what the requirements and the chart show, because in that resolution, it has a reprint of the zoning chart, the bottom of the first page of the resolution, and it's got all of the bulk requirements, except for parking. Parking is blank. There's no reference to dealing, frankly, with parking, and we know at that hearing, there was no application for any variance dealing with parking. There was no application for a site plan dealing with parking. The application was only for the 9 variances that you see above,
Well, Mr.
not
Feinberg, on the
parking.
next page, is that top line?
It's right
does that
there.
Deal with.
The whole chart's always there, I promise.
Pardon me?
It just
Does that
goes on to
deal
the
with
next page.
The next
Feinberg, we
page,
didn't leave out
At the very
parking.
top, see it?
See where it says 222?
See where it says RSIS?
It's the rest
Yeah,
of
4 bedrooms.
And then it goes across
the
to
rest of the
two
chart.
and a 2.
It's 2
And
required,
it
2
says it's
done.
conforming.
That's referring
Cut
to
and
the
paste
parking?
the thing that's in,
RSIS, I guess it does refer to the parking,
it's just the
right?
chart continues to the next page.
Okay.
Yeah.
If it's referring to number of parking, yeah,
number
that's not in dispute. Not in dispute that they need 2 parking spots.
It was there. It was-
Okay, so I appreciate that clarification. In the resolution itself, we have Miss Amy again quoted for having stated in the resolution, paragraph number 8, In accordance with the HPC request, the front of the home is not being altered from the streetscape, and the development and renovations are principally in the rear of the home. Well, it is being altered from the streetscape, because now you have a front parking spot. And the development and renovations are principally in the rear of the home, true, but you also had a change to the front. So that's not a complete recitation of what Miss Amy, or explanation of what she said. Again, there's no discussion noted of any parking space in any prior HPC transcript for conceptual review. The conditions that were imposed by this board, condition 8 is the one that says the applicant will keep the second parking spot and deal with concerns of Shade Tree Commission and board engineer. Again, there's no dispute there. They are to have a second parking spot. What that doesn't say is where it should be. And most importantly,
Well, hold on, Mr. Farmer, are you in my resolution still?
I'm still on the
It
resolution.
incorporates the site plan. This is exactly where the parking's supposed to be. We always approve it with the parking plans incorporated. It's the first page of the resolution, and it cites all of the plans that are included. So the approval is consistent with plans that we approve. So I just want to be clear that the
Yeah.
resolution doesn't leave out where the parking is. It has a site plan that is part of the record that says exactly where the parking is.
That was quite clear, and then there was another condition, because of where it was, it required the removal of that cedar tree in the front, and then we had a further condition that they would do a 2-for-1 replacement of that tree in accordance with the
So
ordinance.
we knew where the parking was.
So we knew exactly where that parking spot was.
Okay. Then we have paragraph 10. This project is located within the historic district. Historic Preservation Commission approval will be required. Well, I know that's in all of your resolutions. The HPC is a similar language that approvals from other boards have to be obtained. But what does that mean if you give it no meaning? What does it mean if you say, oh, well, on this particular portion of the plan, they don't have to approve it? That's what the applicant is arguing, and he's arguing that by saying, well, you've already made a decision with regard to that parking spot. I would contest that on the basis of jurisdiction. This board has a jurisdiction, has the power set out in the land use law to grant variances and other things, but it doesn't have the authority to deal with design. It doesn't have the authority to deal with what other boards do, particularly the HPC. The HPC has no authority to deal with what you do. It doesn't deal with zoning concerns. You are looking at this, I would argue, from a zoning perspective, as you should. You need 2 spaces. That's a zoning concern. But where it goes, that's an HPC concern. Now you're dealing with design. They're it's the same word, but you're looking at it from 2 different perspectives. One is zoning, one is design. And when you're looking at it from design, you're looking at where it should be on the lot. It's another layer of review that we have here only because the property is in the historic district. If you're not in the historic district, you don't have to be concerned about that. But in the historic district, you do have this second layer of review that any property has to be. Let's look at Exhibit E. We're up to that.
In that regard, Mr. Feinberg, I've said this before, I just want my board to understand it because it's very confusing, and I'm not saying it's intentional, but we're always hearing about that. We have absolutely the authority to decide where parking goes because it impacts safety issues and there are engineering considerations, and we have an engineer and you do not. And I've gone through this before on an angled parking in Elmira.
I don't disagree.
So we may both touch that, but I am begging you, and I'm begging the HPC, that if you're going to put your hands on parking, that you do it before they come to us, because it's an area of potential overlap, and to not deal with it before it gets to us really is kind of irresponsible, because we've had this before, and I've said it before, that parking is primarily what we deal with, but you also touch it because of streetscape. But to do it after we've heard it and dealt with the parking is you have to do it at the first hearing. Now, maybe this time it'll turn out and it'll right itself, maybe at the expense of this applicant. But if you're going to do parking, do it before we do parking. Don't do it after. It's not helpful to give us advice after we decide. You understand?
The problem is it
Please
puts
take
us,
that back to your client,
yeah,
to
it
your
puts us a conflict with the HPC, I think. And perhaps it needs to be incorporated on the checklist.
Well, I think one of the ways to address that is to be sure that these applications for development are referred back to the HPC. I don't think this one was. I think this came, and Mr. Gilzunas, correct me if I'm wrong, I think they came on their own to the HPC. It wasn't a specific referral back to the HPC for
How many times
comment.
do we have to go there? They went there once, they came, we prefer not to do it before they have conceptual, so that we know what variances we need. So we've just encouraged people like Ron Galzunas, who really knows what he's doing, almost would never come in here with an application before getting conceptual, because he knows it's a horrible waste of time, because if he goes and gets approval for a new wing, and he goes and sees you guys say, that wing's not appropriate architecturally, then you just get a variance for a wing that he can't build anyway. So they come and they do the big things here. Obviously, parking has become a big thing. We just had 3 or 4, one applicant here 4 times over parking, because it kept bouncing back and forth. And now we have one here where no one thought to talk about, it looks to me like they did talk about parking, but perhaps parking wasn't addressed in the first hearing or something. And now we're doing it again, and now we're left in a position we have to blow up our prior approval, or do something you think negatively impacts the streetscape. And it's unfair to this board that I have to advise about parking issues when we don't have the picture ahead of time. So, parking is, it's a hybrid, so it's got to be done first.
And if this had been properly brought to the HPC by the applicant, we're going to park in the front.
They told
Other
you
than
they couldn't
drawing a
park in the-
triangle on a plan,
They told you they couldn't park in the back, so unless they were going to park in the living room, it seems like they were probably going to park in the front.
the design, as you see, the design was in flux all along. They made major changes to this
Okay.
as we
Well,
went along.
Whatever the case may be.
Well, let's go, I'll finish up here with the record here. The application that came to the HPC for final now, they've applied for a permit. Now they're looking for final. Again, the first page. What they're looking for is, in addition to the rear of the home, repair, replace foundation, no height change, refinish porch, house, and garage. It doesn't mention in the application itself parking in the front, but now we have the plan. This is the plan, it's part of Exhibit E that Mr. Galzunas presented. Now look at the lower left-hand corner, and you can see the differences. This is for final, this is for a certificate of appropriateness to the HPC. Now, the applicant draws in a rectangle over that triangle area. He gives dimensions for the parking, he labels it as parking. On the left of the drawing, he puts parking front, crystal clear what they intend to do there for the first time. And he even draws in a 15-foot proposed curb cut, 15 feet. That was not on any prior plan. It makes you wonder what happened to that parking spot on the street. Now we have a 15-foot curb cut. So nobody can make the mistake that, or be unaware that this applicant intends to park in the lower left portion of that property in front of the building. It's labeled correctly, its dimensions are given, it's described, and you even put in a 15-foot curb cut. Looking at the transcript of that meeting. Mr. Carroll, page 6, beginning at line 22. Well, my only question would be, we are approving parking in the front yard rather than a house that did not have parking other than a common driveway, and do we really want to approve that and open that door? Certainly is parking on the street and the ability, even with meters, to own a space in front of your house for a very fair fee for parking in the street. That definitely is a very dominating feature that takes away from all the nice things you've done to the building. And Miss Amy, I would expect that we would have to go back to the zoning board for a parking variance if we were to remove it. Yes, she would. And she has that option.
If we granted the variance, would the HPC give them approval?
Pardon me?
Suppose that they get the variance, never mind.
Well, just speculating again, they could apply for a variance for one spot, or they could apply for a variance for that spot in the front. They have the option, if they don't like the city's option of parking and paying for a street spot.
I was going to say, if we give them the,
But it continues in the transcript. And this is, well, I would again reference what Mrs. Carroll said. It's a very dominating feature, that parking in the front. On page 8 of the transcript, beginning at line 9, Chairman Copeland, we have not approved front parking in applications in Cape May for obvious reasons, because people during our period of significance didn't have cars, and our effort is to preserve the streetscape as much as possible going into the future. I think there were, frankly, two distortions of that comment in the statement that Mr. Galzunas presented to you in his booklet. He says that the HPC said that, we've never approved parking. We wouldn't do that under any circumstance. As you can see, that's not what was said by the chairman. He just says we haven't approved parking on applications. That's not to say that they wouldn't if the appropriate circumstance came before them, but to that point, they didn't, and probably because people know you don't propose parking in front of your building in the historic zone. He talks about people during the period of significance didn't have cars. He didn't mention that we're not talking about this house, when this was built. And Mr. Galzunas would construe that to read, well, this 1920 Sears house, obviously in 1920 people had cars. We're talking about the period of significance, which is a technical term in historic parlance, meaning the Victorian era, actually right up to 1940. And most of these homes that were built in the historic district come from the Victorian era. I believe there's 600 of them. And during that period of time, obviously, people didn't have cars, but we are left with their appearance today, and that's what we're trying to preserve. I'm glad Mr. Galzunas presented this map. He presented it to stress, well, such a wide area being affected. Yeah, that's true. As you know, the whole city of Cape May is a historic landmark. Very few cities in the country can make that claim. The HPC's jurisdiction is over the historic district. It doesn't deal with Village Green or anything outside of that district. It deals with this because there are so many homes to be protected. And what this board does in applications like this can have an effect on a large-scale portion of the city, the historic portion of the city. Now, the resolution which the HPC passed. Obviously, this is the most important document because it sets out the reasons for why the HPC did what it did. When you're considering this application, as you've heard many times now, the standard is, did the HPC act arbitrarily, capriciously? In other words, did they have any reasons to support what they did? I would suggest to you they enumerated 6. If you look through paragraph 4 of the resolution, beginning with subsection 4C, it makes reference to the Cape May design standards incorporated by this zoning ordinance. regarding off-street parking. That's page 64 of the design standards attached. Now, you've all been given a copy of that. Let me put my finger on it. Okay. That's this document, page 64. And it says here, it quotes from the design standards, which is part of the zoning ordinance. It's noted there was much less paving in Cape May in the 19th and early 20th centuries, and most buildings were surrounded by landscaping. The setting of many historic buildings and the character of the city as a whole have been altered by the introduction of large areas of paved driveways and off-street parking. It's further noted that new driveways and off-street parking shall be located as unobtrusively as possible. Locating off-street parking in front yards is not appropriate. What could be more black and white and clear than that statement? Locating off-street parking in front yards is not appropriate, meaning not appropriate in for a historic house in a historic district. Locating off-street parking in the side yard is not appropriate if it's an area visible from the street or the front yard. That's because they didn't do it in the historic period of significance. That's what we're trying to preserve and protect. Driveways and alleys should be used to access side and rear parking areas and garages. Abutting new driveways or off-street parking areas to historic structures is not appropriate. And then D, reason 2, the subject property is rated contributing. The proposed plan for off-street parking space is in front of a residence, of that residence is not appropriate and violative of the stated design standards. E, 3, the proposed parking in front of a residence is detrimental to the historic integrity of the property and the district. The HPC made the finding that if you put a parking spot in front of this building, and contrary to what the design standard says, you're going to hurt the historic integrity of that building and the district as a whole. That's a finding that they made. F, parking in front of premises is a dominant feature. Such a new design element would be detrimental to the streetscape. There was not final parking in the period of significance. Everything else they want to do in G is fine. The building was good. All the design changes were good. It was just this one feature that was not appropriate. So did they have reasons? They had 6 of them. Why they didn't approve this particular application. The vote was approved 7-0. The concern here that the applicant argues is that if you don't do what he wishes you to do, or if you do affirm what the HPC does, that's going to affect all these properties throughout the town. Well, throughout the historic district, yes. But if you don't uphold the zoning ordinance in the appropriate sections and the design standards so that you do allow, from a zoning perspective, parking in the front, where you don't have reasons such as safety, turnaround, site triangles, we have valid reasons to approve parking in some situations. But here, where you don't have those concerns, if you approve that, the next application that comes before you, isn't that going to have a parking spot in front of it? You know that it would. And what's that going to do to the historic district? Very briefly, the zoning ordinance. I had read you what I think is the most important one, that neither the applicant nor the commission shall be bound by any informational meeting or conceptual review. That goes right to the heart of his argument. We're relying on it. Shouldn't be relying on it. By law, it's not binding on the HPC, nor is it binding on you. You can come in with another application. You can change the garage in the back. There's a lot of things you can do with the property. You don't have to do what occurred at the conceptual meetings. You're not bound to it. It'd be very easy to say, well, you already said that you're going to design your rear this way. We're going to hold you to it. No, we can't at final. They're not bound to it. Neither is the HPC bound to what happened at conceptual. Paragraph E of that same section, 525-37E, number 3, says the commission shall issue a denial of a certificate of appropriateness to the applicant if it finds the permit application inappropriate to the historic district or site or not in conformity with design guidelines. The Historic Preservation Commission found that it was inappropriate to the historic district and site and was not in conformity with design guidelines, which I just read you. They were bound to issue that denial of a certificate of appropriateness. Had they done otherwise, in face of what the design standards say, then you could say that was unlawful. They were arbitrary and capricious. They didn't follow the law. They didn't follow the design standards. Had they done anything other than what they did, the standard that appears in E, number 5, been part of this record, has been cited by the engineer, and I know Mr. King has cited this before, that this determination on these issues is within its authority, the HPC, and should be entitled to due deference. You may have a different opinion here with regard to the location of this parking spot, but they are entitled the weight, credence, deference to what they did because they had reasons to do it. In section 525-38, referral from municipal agencies, paragraph D, an approval by the planning board or zoning board of adjustment, as the case may be, does not relieve the applicant of the requirement of obtaining a certificate of appropriateness for those aspects of the change not approved by the application for development. You approved parking. You approved parking because of zoning concerns. You did not approve parking because of design concerns. And am I wrong in that? I don't think there's anything in the record that said that this board, when you approved the location of the parking at that spot, if in fact you did so because of design criteria. No, you were looking at it through your zoning eyes, as you properly should. But where there is a concern for design, it then goes to the Historic Preservation Commission, and the section of the ordinance that I just read you says, in that case, they have to get a certificate of appropriateness, which they did not do for parking. And I think this is another very important section. The next section, 525-39. That's the section that sets out standards and design guidelines. Bear with me with this, because it should be part of this record. The purpose of this section is to provide uniform standards, design guidelines, and criteria for the regulation of historic sites and districts for use by the Historic Preservation Commission. All projects requiring a certificate of appropriateness, which is this, and all applications for development in historic districts or on historic sites, which was what was brought to you, an application for development, shall be governed by the principles of the Secretary of the Interior's standards for rehabilitation, the Secretary of the Interior's standards for the treatment of historic properties with guidelines for preserving, rehabilitating, restoring, and reconstructing historic buildings, and the Cape May design guidelines for the historic district, which are adopted as an appendix to this section and which are incorporated herein by reference. This section says that applications to the HPC, applications to you for development should be governed by Cape May design standards. If you reject the design standard here, which says no parking in front of the building, you are not adhering to the design standards, and you are not frankly adhering to this section of the zoning ordinance, which says you shall review these in accordance with the design standards. Very important section. And the word is in this section, shall. Not may, not should, shall. The very last section I'm going to read to you is 525-43, section 525-43 of the zoning ordinance. The requirements of this article shall be considered to be in addition to, and in no case shall they be interpreted as a substitute for any other approval, permit, or other action as otherwise provided by law. I'm not arguing to you that the HPC standards should substitute for your standards. I'm arguing to you what this section says, it should be considered in addition to what you did. It's a separate regulation dealing with design standards. That was not before you. It can't be before you because you don't have that jurisdiction, just like the HPC does not have zoning jurisdiction. So I thank you very much for your time. I know I went on for a while, and that's our position. We certainly hope you affirm what the HPC did.
Thank you.
Yeah, Mr. King, I won't take long, but since there's much reference made to what I said and what I characterized, I have to respond as well. I think I'm hearing for the first time this evening that principles and guidelines are now elevated on par with statutory law, promulgated in accordance with other statutes and what will govern us. I'm confused as to what they are. The HPC seems to want to hold this board to these laws, these principles, these guidelines are something now that are intransient. Is there a variance procedure from these principles, from these guidelines? And if there is, who determines that? Not this board. Apparently, according to the HPC, this board doesn't have jurisdiction to do that. You will abide, Mr. Harless, by the principles and guidelines in that pamphlet and throw your engineer book out the window, because when it comes to parking, you have nothing to say. I mean, that's what I'm hearing here, and that's unreasonable. And we've sat here for 15 minutes and listened to point after point after point of all these facts and findings bootstrapped into this resolution. This is nothing but an attempt to cure what was not done at the hearing, to pack a resolution with all of that information. None of it. We've read a couple sentences in the transcript that touched upon this. None of this was in there. If the zoning board, if Mr. King put that in a resolution that wound up in front of a court, the judge would, that's arbitrary and capricious in and of itself. So I object to even having that's not part of the hearing. That was not in the hearing. None of that was discussed. And I mean, to talk about what was discussed at the hearing, this is what was in the architect's mind when she was at the hearing, when she had to go back for final. This is what architects think about when they go back for final. In response to Mr. Stevenson's question, as he says at page 7, that's the September 20 transcript, the railing systems, currently, they're pressure-treated wood. Miss Amy, the existing rear deck, Mr. Stevenson, no, the existing railing. Miss Amy, oh, no, the steps, yes, Mr. Stevenson, okay. And you're proposing wood, is that going to be painted, natural? Miss Amy, it would be painted wood rail, yes, Mr. Stevenson. And additionally, the circular stairway, what materials on that? Metal, galvanized, is it painted? Miss Amy, it would be metal, ideally powder coated, and I think if we do a wood handrail on it, that would be ideal. I would have to confer with my client. In all honesty, we haven't talked about the metal stair material, but that is something we would do for final. That's what architects do for final. To move on to what I supposedly distorted the effect of the statement that Mr. Copeland, we have not approved the front parking on applications in Cape May. We have not approved front parking on applications in Cape May for obvious reasons, because people during our period of significance didn't have cars. That is an unequivocal, specific, clear statement, a statement of past, future, and in this context, a future context. They're not going to approve it. We're here. This person's here for an application, and she's told no. We don't approve that. I don't know how I distorted that, but if you read before that, even Mr. Vice Chairman Carroll talked about parking in the front. Well, my only question would be, we are approving parking in the front yard rather than a house that did not have parking other than a common driveway. And do we really want to approve that and open that door? Well, that means to me, no parking in the future in the front at all. We get, don't open the door, you can't walk through it. So I don't know how I distorted that. Now, I think, the HPC's opening comments, shame on them, shame on them. I don't know shame on who for relying on conceptual. I set forth the reasons why we needed to rely on them. I think they're pretty real. I think they're pretty substantive. I think they're quantitative in time and money. So no, not shame on me, not shame on the board, not shame on the applicant, not shame on the professional, shame on no one. We want a process that works here. We want a process that we can rely on, not change, come back, change, come back. It's no benefit to the applicant that it's not binding on them. If they want to change their mind, they're free to redesign projects 10, 15 times if they have the money and time. It's on them. It was their decision. They have to come back. They have to revise the plans. So no, it shouldn't be binding on them. I think Mr. Feinberg showed his hand of cards when he was going through this, when he was pointing out on the last set of plans that went to final approval, when he was pointing out the additional detail. No one can make a mistake that someone is going to park in the lower left-hand corner of the front property. Well, who would have made that mistake? The HPC? Mr. Feinberg holds up the application, 3 applications here, and it's a one-page application, and there's 5 lines, and that's what you put in there that you're applying for. Are you telling me that that's all the HPC ever looks at when an application comes before them, is what an applicant puts on those 5 lines, and if it's not on those 5 lines, then oh well? I don't believe that for a second. I think they do a good job, and I think they scrutinize those applications. It doesn't look like, from what I've heard, that the HPC wants to bear any responsibility for what has happened here. None. They want to put it squarely upon the shoulders of the applicant, that the applicant didn't take them by the hand and lead them through the application, that there was no obligation on the HPC to scrutinize the plans and look. Who knows what they're going to find important? We never know as applicants when we come before boards. We can guess based on past experience what the board's interested in, what's their concern. We can try to address those things, but we never know for sure what the board's going to take an issue with, whether it be HPC or this board or the planning board. We can't possibly know. But it's not all on the shoulders of the applicant. It can't be. So there was a mistake here. Mr. Feinberg's essentially conceded that. There was a mistake. Why did it happen? We're sorry that it happened. You don't think that we want to be here. But it happened. And I'm not going to sit here and agree and concede that the HPC bore no responsibility for this. I'm sorry. There has to be finality. Mr. King's pointed out over and over again. And then to elevate the guidelines and standards and create this procedure that doesn't exist. Yes, these are guidelines, these are principles. Principles are reduced to statutes on occasion, they're codified on occasion, but principles are something that guide us, that steer us, that give us a direction. It's not statutory law. So that is absolutely inappropriate. It's inappropriate to bootstrap a resolution and pack it full of 6 different justifications of why the board did what it did. So, look, we can see what's happening here. What's happening here is a result of not reading the plan correctly. Look,
And on a preposition.
yeah. I think, Mr. King, you're correct. The dilemma, like you've used the word blow up, but, another way to look at that is to say that, there's detrimental reliance here. Things fall apart because of what happened. Board members, the applicants have to come back to the board. Another variance application, another notice. Let me tell you what, that's another 10 grand in 6 months. Now, that's a heck of a thing to weigh. And, look, when you get to weighing it, this board is well aware of what all those factors are and with the parking. I think the HPC doesn't like the answer. And look, they're zealots, they're good zealots, they're protecting the city, they're protecting the HPC. I do not fault them for that. But at some point, there has to be balance in the world. We can't have guidelines that you're breaking the law if they're not filed. That's not possible. We're allowed to have variance. We're allowed to have deviations. We have to have parking. We have to live. I'm sorry, but we don't live in the 17th or 18th century. We have cars. We have to deal with them. We have to have a balance. We have to have something that's not, you can't open the door, and we're not going to approve it. If you want to know what I think is arbitrary and capricious, that's probably highest, one of the things that's highest on the list. Thank you.
I have 1 minute, Madam Chairman.
Yeah, we have 2 more applications, so.
Pardon me?
We have 2 more applications, and it's on the record, so.
I'll only be a minute because it was such a attack on the resolution itself. The resolution is a memorializing resolution. It's part of the record. In addition to the transcript, is a very important part of the record. According to Mr. Cox, I know everybody is familiar with his treatise, the memorializing resolution forms the primary basis for review on appeal. So it's a very important document, and he says, and I know Mr. King knows this, a carefully prepared, detailed resolution containing findings and conclusions that fully explain the basis on which the board has acted, with ample reference to the record and the statutory standards, may serve to sustain the board's action even in the face of no deliberation on the record. So if that transcript were half the size that it is, the resolution is still the most important document. That's all.
Can I ask for something? I just want to clarify this. The HPC on March 21st did a final approval with the condition of not having the front parking. It then went to zoning on the 24th, and it was approved based on HPC approval will be required.
Are you saying that the final HPC approval was before the
We-
zoning hearing?
No, it happened before. You got
I was
that
just looking at
resolution,
what was in
that
here.
resolution came out a month after. We were, it went to HPC and then it went to,
It went the way it usually goes. It went conceptual, then to zoning, based on what happened.
And
in
then back to
conceptual,
conceptual.
And
then
then it went
final.
back again. Okay, I was just looking at the dates on these, and that's the way it looked to me.
I don't know the exact dates, but that's how it went.
Okay.
And Rich, one other question. The design standards are part of the city ordinance, is that
Yeah,
correct?
I didn't quite agree with Mr. Gazunas
Okay,
on
I
that.
wanted to clarify.
We
Yep.
actually adopted the
Yep, okay,
guidelines. We don't call them guidelines, we call them standards, and
Yep.
we adopted them as part of our ordinance, so.
okay, all right, thank you.
How long ago were they adopted?
5 years ago or so. We changed the word to standards
I
and
was
adopted.
about that.
I'd say 5 to 6 years ago, right after I came onto the board. Any other board discussion?
Anybody else?
2017.
Any more questions?
Yeah, Rich, would you review again your comment earlier, depending on, if we were to vote to support HPC, then the applicant has to go back through an entire review again?
Right. There was an application, I think you were here, where they came in with this whole project seeking a bunch of different variances, including the floor area ratio variance, and that was granted. For example, one of the reasons you can grant a floor area ratio variance is the property can accommodate the extra space for the floor area. One of the reasons that it can accommodate it is because it had compliant parking. Okay? So a lot of the reasons why you gave the variances you gave before was because there was compliant parking. If you're now going to say that they that the only way they can build this project is by they have to eliminate a parking space, your prior approval doesn't work because they can't build in compliance with the prior approval. Okay? Now, so that, do you understand? So that's why when I say you're blowing up their prior approval, if they go into the building department with that prior approval and they say, but we're not putting a parking space in the front, they say, well, then you're not building it. I mean, that's just how it should work in a perfect, if our system is working, that's what should happen. Craig would catch it.
I don't sign the compliance plans because they're not consistent with your approval.
Right, okay, so that's just an input, that's something that can happen. We just need to understand that, but you're also, you know, HPC is planning for the long term, right? So, you know, what you're kind of all gonna wrestle with is, maybe the HPC didn't have their best night when they did that conceptual approval and didn't really focus on parking as closely and ask, well, what are these triangles or where is this parking? You have to weigh in your mind whether now you're gonna say, well, we're gonna allow parking in front of a house for the next 100 years, when there wasn't parking in front of the house for 100 years, right? So, you know, because they missed it one night, all right? So is it unreasonable for them to now, when they get final and it's clearer to them and they say, wait a minute, we don't want parking in the front, you have to decide, is that unreasonable? That's gonna be your standard. I'm gonna read that in a minute. Well, you know, is that unreasonable? And you have to say, well, should they, just because they missed it one night, do they have to, in their final one, say, well, we're gonna abandon one of our primary guidelines that says no parking in the front? Okay? So you have to decide that, and it's a hard decision, but I want you to think about all the other implications, okay? And so you're deciding if it was arbitrary, capricious, unreasonable, or contrary to law for the HPC to enforce their guideline at the final approval stage. Now, normally that would be easy. The answer to that would be, no, of course they're supposed to enforce their guidelines. This one's a little tougher because, you know, the parking kind of falls within both of your jurisdictions, and they're supposed to advise you, and they're supposed to give you advice ahead of time, not after. That's how the whole system is set up, to try to catch things that can affect your variances ahead of time so applicants don't get bounced around. So maybe in this instance it's unreasonable, maybe it is, maybe it isn't. That's for you guys to decide. So you have a hard decision to make. I think you understand all the implications.
Can a parking spot be bought on the street instead of that and still be passed?
It's not, enforces them to do that.
They're all, it won't work, it'd be an off-site parking spot, and
Still need a variance.
It still need
Right.
a variance. Now, they can come back for a variance, and it is an expensive, onerous, somewhat time-consuming process, but there can be waivers, and it's gonna look a lot like the last one. It's gonna be missing a parking space. And by the way, the board may not grant that variance. The board may have a bunch of residents come out and say, we'd rather have the parking space, which is sort of what happened. You weren't doing it in the HPC context. You weren't addressing it because it wasn't really brought on our radar that there was this streetscape concern, at least from what I recall. But you may say, just like we've done before, the HPC says they didn't want parking in front of the house on Beach, and we said, no, or they didn't want it under the house, and we had that whole thing. You may say, we're granting the variance, and we think it's unreasonable to not put that parking up front. We need parking, and there's already a drive-through there to get back to the garage, so it's not like there's no driveway there in the first place. So you may want to have that second parking space there despite what the HPC says. So that's kind of for another day.
But Rich, I'm going to, on that point, I'm going to need 5 minutes to confer with my client to make sure he understands the implication you're talking about going back to the zoning board. Well, I'd prefer speaking with you, just 2 minutes.
But how does that affect what we're doing?
If you, on the vote, if you vote to uphold the HPC, he has to come back to,
What's the difference?
but his existing approval is terminated. He can't build.
It is already. He's not gonna get a building permit
okay.
unless the HPC
Um,
approves it.
but-
You know what I mean? Like, I mean, I hear you, but I'm just
Right.
saying that he can't
Okay.
build right now anyway.
All right, the other issue is, I wasn't clear to me
You can
100%.
talk to your client if you want to. I would never not let someone talk to their client. If you want to talk to your client, you can. I don't understand.
No,
what would
I
slow us
understand.
down, but-
I just want to make sure that the board understands, it wasn't 100% clear to me, that there's nothing here tonight that's going to stop the HPC in the future from applying their standards. The question is when they got applied in this process. I want to make sure everybody understands that. It's not a train that's going to go down the tracks and everybody gets parking in the front. I think that might be a misconception that was alluded to. The HPC can apply the parking standards, all the standards, moving forward on every application that comes before it. All we're saying is they were applied on this case after we received the variance approval. That's all.
There's an extensive record on that, and there's two sides of that story. The guideline says you're supposed to park in the rear, and if you're not going to do that, the HPC says you got to make that really clear to us that you're going to deviate from our standards, and you should have done that in the conceptual things to make it clear. These folks say, but we told you we couldn't park in the back, and we had plans set of triangles where the parking was. So where'd you think the parking was? So that's all on the record. You guys weigh that as part of the reasonableness or unreasonableness, and this is the standard, and then you apply it and vote so we'll get to another application. So the standard you're going to apply is the determination of the Historic Preservation Commission may be overturned only if the Zoning Board of Adjustment finds that the Historic Preservation Commission determination was arbitrary, capricious, unreasonable, or contrary to law. So take all elements of the record, and you make that decision. I'm going to ask you to either, sometimes this gets confusing.
Yeah.
So the motion, I've done it this way before, and it kind of works. I'm sorry, gentlemen, but it does work. I'm going to ask you to vote if you agree with Mr. Feinberg or if you agree with the position of Mr. Gelzunis. So that's the easiest way to do it, because you know exactly where they stand. So rather than get into affirmance, reversal, just whether you agree with the applicant is Mr. Gelzunis or the HPC, and you know, that's the motion I'd recommend being made is that the matter is to affirm the HPC. We'll do it in the positive. The vote is to affirm, okay? But I'm going to ask you to vote either Mr. Gelzunis' position or Mr. Feinberg's position, and then that'll be clear. Does everyone understand that?
Specifically.
Yeah, say I agree with the Mr. Gelzunis, or you can say applicant or HPC, but just pick one or the other, okay? Because everyone will get confused, I think, if we do it the other way.
Let me ask you one other question, Rich. Under the statutes of the municipal authorities, we have no ability to have any latitude on this application. It's either yes or no.
Say what's on your mind.
Well, I guess what I'm suggesting is, do we have the ability, as the zoning board, to tonight grant them a variance?
No.
They have to
It
go
wasn't
back.
requested. A variance wasn't
Okay, all
requested.
right.
And there wasn't notice for a variance.
Okay, that's all I need.
I am of the opinion that technically, I do think you can seek a variance from an HPC guideline. That's just my opinion. Cox kind of agrees with me. When it's a crystal clear, firm guideline, that's an absolute, I think you can seek a variance for it. So if there says no solar panels on roofs, I think you can seek a variance for a solar panel on a roof. That's just my opinion, but that's not the standard we're in right now, that's not where we sit. There wasn't all the notice and expense that it comes with doing a variance like that, that's not where we are. So we are in an appeal of the HPC's determination. Okay?
Craig's, have we heard everything we can possibly
I
hear?
don't think he has anything.
What's
Do you
that?
have anything else to say, Craig?
No, everything, I mean, you're relying on the record below, so I'm not going to add.
All right.
So the motion is to affirm it. The way you're going to vote is you're either going to agree with Mr. Feinberg or Mr. Galzunas, the applicant and the HPC.
Do we have a
I'm
motion?
going to say it out loud. If you say the HPC, that technically means that you're affirming their decision.
Well, you want that motion? The motion would be to affirm the decision of the HPC. Is that the motion? And-
Yes.
Do you want, or would you entertain that motion, Ms. Chairman? Okay, I will formally make the motion to affirm the HPC decision.
I'll second the motion.
Thank you. Motion by Mr. Murray, seconded by Mrs. McDade. Mrs. Werner?
I'm saying no, only because I do see that that parking was on all of the plans from the very beginning. So I think it should have been addressed sooner.
You agree with the applicant?
Yes.
Mr. Ledwin?
Yes.
So you agree with Mr. Feinberg? You agree with the HPC?
Yes.
Okay. No one's following my rule. This is why I have to ask.
Mrs. Notch?
I agree with the HPC.
Mr. Walsh?
Mr. Feinberg.
Mrs. McDade?
I have a real conflict with this application between the two of them. I think that there should have been, on the part of the applicant, I wish they had done a better job at identifying that parking. I wish they had done a better job at making sure they were very clear. The transcripts, I feel, there's some gaps in some of the conversations that could have happened or may have happened. At the same time, I'm a supporter of HPC. The design standards are publicized. They're out there. They're there for a reason. So I'm very challenged by this one, I have to be perfectly honest. But I will find for the applicant.
Mr. Murray?
This is an extremely difficult decision to make, I thought, because, again, we have competing interests here in our city. But again, we are obligated to do our job, and I will try to do that. I'm going to vote to agree with Mr. Galzunas. So I'm going to vote no against the HPC. And the reason is, again, not because when I looked at the record, when I looked at their resolution, I thought that they were not being arbitrary or capricious in accordance with the record of the resolution itself. But looking at the procedure that went through there, I would agree that this parking issue was there at the beginning. And I think that it's basic that you should be able to rely upon things as they go along, and things should not be changed in the middle. So I'm going to agree with Mr. Galzunas and vote against the HPC.
Mrs. Hutchinson?
I agree with everything that everybody has said. I clearly think that it was on all the plans from the beginning, and I think that the HPC didn't address it. I think that at the final hearing, when Mr. Carroll said, do we want to open the store? To me, it's an afterthought. It's a throw-on at the end of saying, well, we've done all these things, they've done everything we want, but hey, now let's think, what do you think about parking in the front? I'm agreeing with the applicant. It is a difficult thing, and I don't like to go against the HPC. That's because they missed it, I think was clearly on every single thing. I read everything that was in here, and it was almost like you just never discussed it until that last statement by Mr. Carroll.
Okay, so the vote's 4-3, and the board is, I guess, it sounds like it was a finding that in this instance, it's unreasonable to require them to remove the parking. So that's the will of the board, the resolution will so speak. Great job, guys, it was a good argument on both sides. Very well done.
Thank you, everyone. Truly, Ms. Hutchinson, you're correct, very difficult. Hopefully it doesn't happen.
I hope not. The next person's going to come.
Thank you, everybody. Long night.
Yeah. Rich, I do think it is important that, to go back to the HPC through Mr. Feinberg and ask them to include this as part of their checklist or, review process more thoroughly, since we've had so many of these come before us. I think it does put us in a little bit of a challenging and conflict, and I would hate to see for this to continue. So whatever could be done through the HPC to include it on a checklist, Mr. Feinberg, or at least note to the commission that it's, becomes problematic, and it puts the zoning board and the HPC commission in somewhat a conflict, and I don't think that that's what we really want.
I agree with you. As I read, the requirement should be for a referral to the HPC for comment, which you would have before you act. I think that would go a long way to solving the issue.
I don't understand that. It was there for conceptual approval. We're supposed to send it back to you a second time before they come here?
Well,
Why would we do that? They went for conceptual, we're supposed to send them back for referral again? That's why we have the system in place that they come and they say they had conceptual. That's not how to
Well,
do
it
it. Put it on-
shouldn't-
It has to be on a checklist. Parking is an area of overlap. I am begging you to deal with parking at conceptual approval. That's the
Well,
time.
there shouldn't be conceptual until they come to you. Make an application to you, not you made a decision. Make the application. Then it goes to the HPC for conceptual. So they can comment. Yeah, at that point, it would come to the HPC.
So then they have a month between when they file the application, then it goes to HPC. Don't we send you a copy? I thought I required that we send a copy of every application to the HPC. We do. And the idea of that was that if they want to come to the meeting, which in this case they did, by the way, they're entitled to speak and express any concerns and give us the advice they want. So they can have conceptual ahead of time, they get a copy of the application, they're allowed to appear. I think that's, well,
So,
so,
We need,
I think there's stuff in place. All right.
this is the second appeal that we've had. It seems like we've had conceptual.
It's funny you say that. They've been in the process for the last several months of redoing that application. Good place to put it.
The next application, anybody need a break? I need to stand.
Okay, please turn your microphones off, because we can't stop the streaming.
It's a good thing he has a house down here.
Which one is this? Is this Schultz?
This is no, Schultz is last. O'Donnell and Justin Weiner. It's the main thing. Okay. We back? Everybody's back. Okay, we're back in session. Our next application is Thomas O'Donnell and Justin Waymire.
Right. Thank you, Madam Chairperson, members of the board. My name is Thomas D. Keywood. I'm the attorney for the applicants. Tonight I have Mr. and Mrs. O'Donnell here with me. Mr. Weimer was not able to come, so I do have my professional here, Mr. Joseph Ross. I think the board's familiar with Mr. Ross, so I'd like to place them under oath, and so we can get started.
I'm also going to swear in our board engineer. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
All right, your clients didn't get sworn in. You're not going to have them speak?
Oh, I did ask them to.
Okay, you got to raise your right hand and do the thing.
I do.
Do each of you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, thank you, Mr. King. This property is located at 1624 New Jersey Avenue. I know you do have the plans in front of you. It's an addition onto the front of the property, but really the only reason we're really here is because there's no other place to put the pool. And that pool is going to be in the front yard, which would require a variance. So as I always say, you know, I'm the lawyer here, and I think really what you probably come to hear is to hear Mr. Ross. So I'm going to let Mr. Ross explain the project. He was the architect on it, and he can go through it.
Okay, I'll begin by saying we have received conceptual HPC approval on this project. And I thought the project was straightforward until the previous applicant. So you'll tell me. The existing house, you can see probably the best way to view the overall project is on your sketch site plan. And the hash lines, the diagonal lines that go from left to right downward represent the original structure. It's 23.6 feet by 27.6 feet is the ground floor plan. And then it has a 19.1 by 23.6 additional second and third floor overhead. And what we're proposing is to do a 16-foot by 23-foot-6 addition on the front of it to create a porch, a porch that the HPC found to be attractive, and also to enclose part of the carport underneath the house into a enclosed garage area. That necessitates moving the parking forward on the lot, and our goal is to put a pool in. Of course, there is no backyard. You can see from the sketch site plan that there is a 25-foot rear setback, and the rear of the house is at 25 feet, 2.5 inches. So we have 2.5-inch envelope to build in the backyard. Side lights are similar, 8-foot side setbacks on each side, and the actual side setback is 8.2, 8 feet, 2.5 inches. So the house, it's an odd-shaped lot in that the rear section of the lot gets narrower and goes deep, and the original house was placed all the way in the back portion of the lot, leaving a very large front yard. So our intent there is to put in a 264-square-foot pool with appropriate patio arrangement and 2 parking spaces in the front yard. However, all those items are conforming with regard to the front setbacks. In other words, the only nonconformities created by the design are the accessory use in the front yard, the pool use that's shown on the plans. Now, I guess the interesting thing is relative to the application that we just sat and heard. You can see that I've labeled 1, 2, and 3 parking spots. I clearly dashed them in. I clearly showed 9 by 18 parking spaces, and to my recollection, there was no conversation about the inappropriateness of them in the front yard. I will say that would differentiate this property from the other one that was just discussed, is that this property is non-contributing. In other words, Mr. Feynman defined 3 characteristics or qualities of properties in the historic district, and one is key, very important. The next one is contributing, and then he mentioned not rated, which meant there's no opinion on it. What he didn't mention is there's non-contributing. In other words, it's been reviewed, looked at, and decided that it's not contributing to the district. And that's where we fall. So I'm...
I will say for streetscape, that's a little less.
And he acknowledged that there's different sets of criteria that one uses for that. So I'm not anticipating to happen to us what happened to them, that when we go back for final approval, that there will somehow be a problem that was never mentioned before. Clearly, if that's the case, you can see this plan that was in front of HPC clearly identifies, because one of the things we wanted to do here was also to relieve some of the parking burden, and where there were 2 cars partially under the carport and partially outside of the carport already, that one of those cars is now completely enclosed in the garage, and then there's 2 cars in front of the house. But the goal was to increase the parking over the minimum that's required for this site.
Are you in a historic district?
We were required to go in front of the HPC.
Yeah, I was looking at the map, I couldn't quite see.
Yeah, the district is kind of interesting because they identify properties.
Right.
So it's not so much like a graphic block that you can pull out. And our project was identified to be in the district, so we needed to go in front of HPC as a non-contributing structure, and they approved the plans.
Mr. Ross, why is the house built so far back? Like, why is it located there? Is it an artifact from a prior subdivision?
You can look for a guess. I mean, I think it's to maximize the views of the ocean. Like, there's condominium structures around it, and I'm guessing they went all the way to the back because that's where the ocean views are. I couldn't tell you. In some respects, it doesn't make sense.
You're not the original.
No.
And Mr. King, there was a subdivision done, 1989. We did pull the subdivision. Nothing really in there that was definitive of why they did it. I think the only thing that really came up on it was that they wanted to make sure that they had a valid sales agreement, and they approved the subdivision. So the property, Mr. Ross, is, if you had to describe the property, it's narrow?
It's narrow and deep, and is wider in the front than at the rear.
So could I just hold this up? So for a visual, this is the area that you're speaking of?
Yes,
Okay,
that's
all right,
our front yard,
Okay, that's-
which is really, all we have to develop in it. And if we're not permitted to use that in some fruitful way, then it seems
So the
almost
houses
simple.
to the left of it, and then these are
To-
townhouses to the right?
To the right are multifamily units with concrete driveways going up to garages right on the street. And the houses to the left, actually, their backyards are adjoining our front yard. So, again, because they face the other street at the end of the block. So,
But is this,
yeah, that property there, their property, where your finger is right there, is their backyard.
okay, so you're actually,
Our-
it's here? kind of
It-
thing?
Only it widens out just a little bit,
This-
yes.
Okay,
Uh-huh.
all right, okay.
Is there any other questions about?
That would have been helpful to.
I have a question for you. You have 3 parking places, one under the current,
Right, it's going to be in a garaged area, uh-huh.
but currently the driveway is gravel only partway up. What's the intent for the rest of that
Well, it was,
2 and 3?
what's the intent to be pavers. What was there now, or previously, was, it was
Grass.
grass, but
It's actually
Grass pavers.
it had grass pavers, like pavers that the grass grew up through. So it looks like yard, but there are actually blocks with holes in them that you can drive a car on. Does that adequately address your question?
I went and looked at the property.
Yeah.
That's why I asked.
Yeah. It all looks like yard, grass yard, but there's actually grass paver block driveway.
And you would have the same materials?
No, we're intending to be like a nice E.P. Henry paver block.
Okay, is that?
And again, that was presented to HPC in our
Is it
material list.
included here for lot coverage?
Oh, yes, all the lot coverages conform. It's such a large lot,
Well, it's true.
and the pavers, as you know, only count for 50%. So our lot coverage, to answer your question very specifically, the existing lot coverage is 26.1%, and our proposed coverage is 36.2%, and the allowable is 45%. So we're well under the limit provided by the zoning code.
When was this house built?
That's a good question. I think I know the answer.
I can tell you that the subdivision was done in 1989.
And I believe it's 1991.
I actually,
original owners,
according to
or-
tax records, it was 1995 that it was actually constructed.
95, and not the original owners then? Because I was wondering if the board, what would have been their idea, why to put the house so far back, other than ocean views, which is ridiculous because those condominiums block the view on the ocean
A
side.
lot of times, as an architect, a lot of times I go in and I can't, makes no sense to me why something's the way it is, but alls I can do is speculate.
Okay.
Yes, sir.
I had another question for you. On your application on page 6, uh, 16, it says that you don't have a mercantile license? Is that correct? The application's incorrect then?
Let me see, page 6.
Page 6.
It says, does it require you to have one?
Number 16.
Because you rent the property.
So,
The sign in
There's a
front.
rental sign,
the
that's
si-
right.
rental sign in front is.
Absolutely.
You rent the property, so you have to have a mercantile
have a
license.
mercantile license, yeah.
Well, this is wrong then.
Then this is wrong.
Well, that would be a mistake on my part. So,
Is everything else correct in the application?
I would hope so, yes. So, I always tell people I make mistakes daily, I just try not to make the same one twice.
We all do.
There's 26, in fairness, there's 26 paragraphs, that's only 1 out of 26, that's not,
It's a passing grade.
it is, it is.
Sir,
Might ask for a
could
discount.
you just point out on this diagram where the pool equipment is?
The pool equipment is underneath the overhang of the building, near to where the stairs are. The engineer in his review letter has asked us to identify that on the final set.
Okay.
But our intent is to have it. You'll see the garage area, which is hashed in with parking spot number 1, and then a set of steps that goes up to the porch above, but there's still a large concrete area that's under roof, and we intend it to be in that area.
And you don't identify the setback for the pool equipment on your
The
drawing?
pool equipment is outside of the 8-foot setback. It's within the lines of the existing building,
Okay.
which the existing building is conforming in every respect. Are there other questions that I could answer as the architect?
Well, can you tell me under which statute you're seeking the variance? Is this a C1, a C2, what are you looking for?
It's a hardship variance, I think, the fact that it's, the property is such narrowly construed. I think there's, like Mr. Ross, I think, said previously in his testimony, if they're not able to develop that front yard, you know, it really makes the property not really workable.
Well, yeah, the bottom line is there is no way we can form since no developments could come in without a variance because we only have 2.5 inches of available rear yard that we could build within. And whether it's a pool or a doghouse, we're not going to get it in that 2.5 inches. So basically, any development on this lot would require a front yard variance. Any development of an accessory use would require a variance on this lot because there is no way to conform otherwise.
And what will the height of the fence be in the front?
There's a fence on
A 4-foot-high fence around the pool area. And again, the pavers around the pool have been designed in such a way to maintain the ordinance requirements for setbacks.
So all it is front yard.
You said that any accessory use in that front yard would require a variance, is that right?
Correct.
And why is that? Because of, you said something, I'm looking at.
Well, the ordinance requires specifically pool, that's why we're here.
Right.
But again, this question of parking in the last applications got all kinds of radar up for me. The pools are specifically not permitted in the front yard unless a variance is sought.
But what other kind of accessory uses would be, could you think of that would not be?
A garage, a shed,
garage or-
anything? Yeah,
Uh,
any
gr-
accessory.
Well, if the garage, here's the interesting thing. If we built a garage all the way out at the street with it maintaining the 20-foot setback, and then had a little catwalk that went to the house so that it was attached, and was totally conforming, okay, then we wouldn't be here seeking a variance. We could put a little skinny pool right next to it, but that seemed design-wise very inappropriate, for the area and for the project. As it stood, my recollection is the HPC reviewed this, this design pleasingly.
The pool requirements in the code say they have to meet all the setbacks, so in this case, they are meeting the front yard setback. It's setback 20 feet, which is required. What they're not conforming with is the part that says that the pool can't be forward of the face of the structure. So you can't have a pool in a front yard. So because it's oriented between the face of the structure and New Jersey Avenue, that creates the variance. That's the relief that they're seeking.
But you could have some other kind of structure.
But you could have, Mr. Ross is correct, you could have a garage located in that area as long as it met all the setbacks, and they would not need to come here. So they could use it, but the pool has a stricter standard.
A garage can be in a front yard.
Garage can be in a front yard.
And I kind of missed what you said about the mercantile license. Is this a rental property, did you say? or-
They do rent it during the summer.
Okay,
and
so-
that was a mistake on my part.
So there's a mercantile license involved?
Yes.
Okay, yeah, I missed that.
Yeah, and they're in compliance, they have a mercantile.
Yes.
Anybody else have any more questions? Questions? No? Craig, can you agree with me?
Certainly, I'd like to just highlight and give you the summary of my October 6, 2022 report. This is a project located in the RS Residential Seasonal District. The applicant is indicating that they are proposing improvements to the dwelling. None of those necessitate any variance approval. The only thing that they're asking for this board is a variance for the pool located in the front yard. And that is that fine print on the bottom of page 2 of 4 highlights section 525-62A1 that says that can't be located in the front yard area located between the face of the structure and the street. Circling back to completeness review, on page 2 of 4, they asked for one waiver from providing the location of all structures within 50 feet of the property. Based on the nature of this application, we supported that waiver request and did recommend deeming the application complete. Okay, so I talked about the variances, that's completeness. I'll move on to the general review comments. These are standard, should be standard conditions of approval. Item number 1 is they have to comply with first floor elevations, information that has to be provided on the plan, and any construction has to conform with Chapter 258 of the Flood Damage Protection Code. And we've also asked that the flood zone information be included on the plan. Item 2 is highlighting the fact that we did do the stormwater review requirements for this. This is not considered major development and doesn't trigger our stormwater requirements. However, we asked for them to provide the grading information on the plan, which appears to be satisfactory, but we would ask the board to affix the condition that if the improvements change the stormwater runoff patterns, that the applicant is required to provide a grading and drainage plan for approval to the zoning board engineer. 3, this was talked about a little bit. We asked for the pool equipment locations. The pool equipment is considered part of the pool. So Mr. Ross indicated it's being provided under the structure, and that structure is going to meet the setbacks. The pool setback requirements are a little more stringent than the side yard setback requirements, so I'm just highlighting that. So when you add that to the plan, it has to meet the 10 feet setback and not the 8-foot setback that's required for the structure. Okay?
Yes, sir.
4 is the standard condition that the pool safety fencing has to be provided. They've indicated fencing is provided on the plan. 5, city sewer and water department approval is required for the connections to the dwelling. The pool appears to be placed in conflict with existing services, so that should be worked out and shown on the plan.
Yes, we'll, I guess, determine in the field precisely where they go and if there is an actual conflict, but we'll address that with a note
File an
or something.
application with.
Uh-huh.
Okay.
Yes, sir.
Item 6 is there's the requirement to provide 1 street tree, so that should be provided on the plan. 7, we've asked that you coordinate your landscaping species selection with the backyard habitat for birds recommendations by the New Jersey Audubon Society. That's required in accordance with the code. 8 is our standard condition that sidewalk adjacent to the subject site will be replaced to the satisfaction of the engineer. 9 is our standard condition that requires the applicant to post a inspection escrow and ties the issuance of a certificate of occupancy to the acceptance of all the improvements. 10 is compliance with the Cape May Shade Tree Commission, and they did provide a approval dated October 15th. And I'll mention that the fire department has reviewed it and approved it dating 10/18/22, and Public Works has also reviewed and recommended approval dated 10/28/22. 11, standard condition that compliance with all other state, county, and local approvals that may be required. You indicated that conceptual HPC approval has been received. We just need evidence that final HPC approval has been attained. 13 is the requirement to comply with any and all applicable affordable housing requirements at the time of approval or issuance of building permits. And finally, should the board grant approval, the applicant is required to revise the plans consistent with the conditions that the board sets and submit 6 sets of compliance plans to the board engineer for review. That's a summary of my report. I'm happy to answer any questions from the board.
Anybody have any questions for Craig?
Just one observation on page 3 of 4. Craig, I think under review comments, I think that should be, is 20 feet from
New Jersey.
New Jersey, not New York.
I put New York.
I couldn't figure out where that house was located.
Good catch.
To head to New York front.
Sorry for the typo.
Rich, can we also include that there be documentation from HPC of approval of front yard parking before Craig? I mean, in some form or fashion,
Well,
so that we're...
they have to go back for final,
Okay.
so it's supposed to
Well,
happen
then
there.
I would implore you to make sure that that is
I
codified and,
Mr. Ross is on that.
Is the hair still up here? Yes, ma'am, yes. We don't want me coming back in front of this board a second time.
All right. No other questions? So I'm going to open it up to the public. Anybody within 200 feet from the public would like to speak, please come up. You have to turn the microphone on, state your name and your address.
All right, folks, when you come up, it's gonna go like this. I'm gonna swear you in, then you're gonna
Okay.
say your name, you're gonna say your address, but please spell your name, because I have to get it all down so I can put in the resolution, okay? So do it slowly. So I'm gonna swear you in, and state your name, spell it, and then give your address, okay? So go ahead. I'm gonna swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Name?
My name is Alice, A-L-I-C-E, K-K-A-Y, Morris, M-O-R-R-I-S. My address, my legal address is in Cape May is 1621 Beach Avenue.
Okay, go ahead.
All right. Shall I proceed? I appreciate the opportunity to share my concerns about the variance requested by the owners of 1624. My husband and I have owned property next door at 1621 since 1995. Our unit is on the New Jersey side, so our building directly abuts this property. It sounds like at least one member of this commission is familiar with what the property looks like in real life. I think the drawings don't really give you the feel of how congested and unusual this lot is in its real-life placement where it is. The house already appears shoehorned onto a very narrow section at the back of the property, as you saw in your diagram. I'm concerned that the already congested appearance of the property will be exaggerated by the requested extension of the roof line, the significant addition of deck space, and the issue here, which is requiring the variance, is a pool, which will necessitate additional fencing and the movement of proposed parking to the side fence line, and no room for any attendant buffering greenery. So it will be, parking one on top of the other right along our property line. Adding a pool increases the lot coverage, and I think that's significant. Even though the parking is outlined in particular spaces, it's not my sense that those parking spaces will be readily accessible and usable. During the past 2 seasons, when the use of the property as a summer rental has been notable, renters parked cars regularly extended beyond the property's fence line and onto the sidewalk. Walkers on this busy avenue, which is adjacent to Beach 1, were forced to detour into the street. Not happy about it. I walked with my 2 young grandchildren, and I was not alone in having to walk around cars on a regular basis. So I'm concerned that, a movement to even a less accessible parking situation will create more of a problem there. I question whether the proposed parking really matches the needs of the renters and suggest that it's not easily accessible. An additional concern I have, and I'm surprised to hear, is that the fire department has reviewed these plans and approved them. Is that what I understood to hear? It seemed to me that having a pool and parking where you could count on cars being in parking spaces sometimes in front of the house with no real room around the sides would be a barrier to fire trucks. But I have to bow to the fire department on that. But that certainly was something I was concerned about. This property, at least as we can tell, was bought just a few years ago. I guess I want to discuss briefly what I understand this request is called. It's called a hardship variance that you're asking for. I guess I object to the idea of the property owner suffering a hardship here. They purchased this property a couple of years ago. The conditions of the property were evident. I don't know what loss they are experiencing. According to Cape May Rentals.com, where they list their property, it appears to have been successfully rented out by the owner during the summer season of 2022 at a rate of $8,700 a week, with several weekly rentals advertised at $9,500 a week, already booked for the coming season. So I would suggest that if there's any hardship suffered here, I believe it is that of the neighbors whose enjoyment of their properties will be adversely impacted by the requested variances. A pool brings noise, it brings light, it brings activity, it brings crowding, and this property, as you see on the broader map, is surrounded by other homes. It's an atypical property, and I think that argues against the placement and the crowding and additional hardscaping of this property. Thank you for hearing my concerns.
Thank you.
Thank you. How many bedrooms does this property have?
4.
How many how many people do you permit to stay at the property when you do rent it?
No more than 10.
No more than 10, so that's what you publicize?
Yes.
Okay. For the record, is,
So for the record, we say that it sleeps up to 12, but when we do a lease, we say 10, and that's only because of bed configuration.
Okay.
So there's 4 bedrooms.
okay, so for the sake of argument, if you're advertising for up to 12, right? Okay, all right. So just want to make sure we're clear, which could be, in theory, 6 cars. Well,
In fairness, we base our, Craig, can you just,
Yeah.
what do we base our parking on, just so we don't
So
get our
the
records
parking is
messed up?
based on the residential site improvement standards. For 4 bedrooms, there's 2 parking spaces required, and they're proposing 3.
We do recognize that we need more parking. It sort of stops right now. So Joe's plan is to increase the driveway so that someone isn't leaving their car in the basically in the sidewalk. We want them off the sidewalk, correct?
Could you speak in the mic, because I'm a little afraid.
Okay. My name is Patricia Reagan. I am in the
Hold on, we have to do it a certain way. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, can you say your name slowly and spell it for me?
Patricia Reagan, R-A-G-E-N,
And what's your address, Ms. Reagan?
1621 Beach Avenue, Unit 201. I'm directly next door. And as a little background, I was there when it was built. The lot was only supposed to be 40 feet by whatever the back is, 40 foot across, and it wasn't legal. So the fellow that owned the lot owned a house on the corner also, so they rezoned 10 feet in the front so that it would have the 50 foot in the front. But then they built the house in the back in the 40 foot area. That's the way I understood it. And so that's why.
Why did they build it in the back, do you know?
Because the fellow that owned the house on the corner, he liked to look out the back also, and he didn't want anything obstructed from his view. And so he stuck it in that part there.
He owned both of them?
He owned both, yes, yes. I have concerns. I don't have a lot to say, except I have the same concerns as my other people that are here, and that would be the noise, the traffic, and the fact that the pool is in the front. It seems so unusual to me. I don't know of any other place that has a pool in the front. And so I would be against having this variance. That's about all I have to say, okay?
Thank you.
Anyone else within 200 feet?
My name,
This part.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, if you can state your name.
My name is Lee Snyder, 1 Wilmington Avenue.
And you said Snyder, S-N-Y-D-E-R?
Correct.
Okay, thank you.
Okay. Everything that Patricia said about why the house was located is accurate, because Jack, the original owner, wanted to just have, he didn't even allow shrubbery in the back, so it looked like it was his grand backyard. So up until 2 years ago, that lot was just one large lot, okay? As far as background, I'm an architectural engineer. I'm registered I'm a professional engineer in the state of New Jersey and 4 other states. And the current owner, Rich Gensler and Diane Gensler at 7 Wilmington Avenue, and Gensler is Gensler. They could not be here, but they text me a letter. Can't read it?
It's hearsay.
Okay.
I can't have you testify to what other people would say.
Okay.
So-
Well, basically, it's been said before, so, okay.
It's one of the no-nos, sorry. You can't do it.
That's fine. One thing, as far as the calculations for the impervious area, according to the zoning calculations, they actually use a 1.0 factor instead of a 0.5. So I would like some clarification. Why does the zoning issue calculations pertaining to the building and lot coverage percentage, and it says porous paving, paver blocks, gravel, crushed stone, crushed shell, elevated structures, including boardwalks, and other similar structures, surface or improvements are considered impervious cover. Only grass, lawn, and other vegetation is considered non-impervious.
What were you reading from? I'm sorry?
I got this from Bruce, the zoning officer.
Okay. There is a provision in our ordinance that encourages pervious materials.
Right.
Okay, and it's only for residential zones, which this is, and it permits a 50% credit towards lot coverage if you use pervious materials.
And is that in
I'm trying to find it right now, but I can tell you that it certainly exists.
If that's wrong, we've done it wrong about 400 times.
It's not wrong.
Okay,
I
well,
think it's
the
in the
reason,
definition of lot coverage.
the reason that's critical, because if you use a multiplier of 1 instead of 0.5, it's 46.4%, and the allowable is 45.
So, in the definition of lot coverage, the last sentence says, however, in the R1, R2, R3, R4, and RS districts, when calculating lot coverage, the area covered by driveways, walkways, patios, and non-roof decks of permeable construction, water passes through and not off of the surface, are credited for 50% towards lot coverage. So, that's why.
Okay, and there's different inches per hour of runoff?
Okay, time out. Engineer talking to engineer. So I have to explain this to boards all the time. This is meant to be an encouragement to get people to put pervious pavement down, pervious surfaces down. It has no relation to stormwater calculations.
Okay,
It certainly helps stormwater, and I explained that to the board, but it has no direct correlation to the numbers that you and I know how we calculate stormwater runoff.
okay.
There isn't, 50% of the water doesn't pass through.
That's exactly.
In English, that
Well,
means
I-
50% of the
Right.
water doesn't pass through them.
So I've tried to explain that to the boards numerous times, so I know where you're going with that.
Okay, the other thing is the parking. Parking space number 3 is within the 5-foot right-of-way. It says, "No impermeable surface may be constructed within 5 feet of any property line except for necessary driveways and walkways not exceeding 48 inches in width." So
Parking spaces are permitted within that 5 feet along,
okay.
okay?
The other thing is the width of the property. Where the addition is going, the lot is 40-foot wide, but today's code says the lot has to be 50-foot. So how does that impact adding a 16-foot addition back in where it's 40-foot wide instead of 50-foot wide?
So that's an existing non-conforming lot width in that area. But it's not, the pool itself and the structure and setbacks are all the code requirements are met. So that's not triggering any further nonconformity with regards to the lot, its size is the lot size. That's not being changed or altered.
Also, this is just for information, but the 10-inch diameter pine tree is actually on or within the front southwest corner of parking space 3. My next question would be, if you take the 20-foot or 19-foot between the property line and the fence of the pool, and you park 2 cars side by side, you need about 2.5 foot for the door swing. A car is 6.5 foot, 6'8" wide, then you need another 2.5, then you got a 6'8", and then another 2.5 for a door swing, and you're about a foot and a half short. So I don't see how you're going to get 2 cars side by side.
The applicant's meeting the standard 9x18 parking size. It's the requirement of the residential site improvement standard.
And that's okay if you don't have a fence on either side of your door.
The ordinance only requires 9x18 feet clear, and that's what they're providing.
Okay. What about EMS vehicles getting in 2.5 foot? How do you get an EMS vehicle in, or even a wheelchair?
I can't answer that, but the fire department has reviewed this application and recommended approval, so.
Craig, aside from that, can you just, where would you get to the house if you had to?
Where would you get into the house if you
If
had?
you had to get to the house in the street, how would you get there?
Down the driveway between the 2 cars?
I would suggest, if there were cars in the parking spots, you still have 15 feet from the edge of the property to the side of the pool, and coming in the other direction, you have actually 19 feet from where the line jogs. So I would argue that an emergency vehicle could get down the side property line if it had to, even if there were cars in the driveway.
Yeah,
I mean, it would destroy the landscaping, and it's highly landscaped lot, but.
I mean, typically, firefighters will tell you that they fight fires from the street, and they won't compromise their vehicles by bringing it that close to a fire. I mean, I've heard that
Okay,
numerous
I'm
times.
talking about an EMS, okay? I don't think the radius is going to allow it, but that's, if that's approved, then,
I'm deferring to the fire department review.
okay. And I guess my final comment is, currently, the rental units allow pets. And more often than not, they lock their pets or dogs in the ground level storage / mechanical room. They go to the beach for 4 hours, and these dogs, they're in a strange location. They're in the dark, and they bark constantly. And I guess I can't do anything about that, but now I gotta live with the noise that, who's gonna control that at 10 o'clock, all noise stops? I mean, how, is there an ordinance, a noise ordinance? And at 10 o'clock, it has, okay, and who enforces that? The neighbors?
Police department.
Call police.
If the owners don't enforce it, you just call the police. And about the third time, they'll come out.
And what happens with, okay, so, and what about dogs? So we could do the same with the dogs.
That's a nuisance also. And perhaps maybe you need to talk to the owners about these issues.
I'm happy to, we'll give you our number afterwards, anytime you have, we live in Cape May, so.
Yeah.
So you don't use this property yourself at all?
We use family and friends, and then we do rent it. But we also have another property in Cape May. So we're here all the time. So I'm happy to give the neighbors my number. My number's actually on the little sign, too.
Okay. And I guess there's the, or is this number 3 parking space, is that going to have to, that's subject to shifting, you're saying? Or because there's a 10-inch diameter pine tree 5 foot off the property line, and it's going to interfere?
Well, actually, sir, and I don't know whether I should address him, but I think you're speaking of the, about a third of the way up the lot on the right-hand side, I mentioned existing pine trees to be retained. There's a 7-inch diameter and a 4-inch diameter. So, and they come out of the same ball or root, but that's the whole reason that parking spot was dropped back enough so that that tree could be retained.
Okay.
I mean, the whole reason that layout is like it is so that we could retain that tree.
Okay, and one last question would be the turnoff to parking space 3. I don't really, that's going to be needed to be increased, but obviously if paver's only 0.5 instead of 1, increasing that or decreasing the angle isn't going to really affect the, impervious area. So I think that's probably. Okay, thank you.
Thank you, sir. Anyone else that would like to speak? Anybody? Anybody beyond 200 feet? Yeah, sure.
Sir, do you swear to tell
I
the truth,
do.
the whole truth, and nothing but the truth?
I do. Kurt Von Seacom, 1505 New Jersey Avenue.
You gotta spell it, sir. You gotta go slow, I gotta write it down.
Right, V as in Victor, O-N, space, capital S as in Sam, E-E-K-A-M-M as in Margarita, Margarita.
That's how I spelled it just like it sounded.
That's great.
What's your address?
1505 New Jersey Avenue. Okay, so I feel for you guys. I feel for the neighbors. I also have a rental property, and I also have a pool on it. And I haven't studied this. I've just been listening from the last one to this one, but I'm not sure what a hardship variance is. I don't know if that's a financial variance or hardship because of the way the property is. But since you have another house in Cape May and you're renting this one, you put a pool in, you're going to go from $8,000 to $10, $11, maybe even $12,000 a week. Just a suggestion for you guys, solves the 40-foot problem, solves probably the parking in the backyard. Move the house forward. Put the pool in the back. You have to redo the sewer and everything anyway. The additional cost you'll pay for within a year and a half of doing that. And having lifted a house and done all that myself, it's really not that bad. It's kind of a nice way to take care of all your existing problems. It's really just a suggestion. I hope you, other than that, I hope you get everything. The pool in the front seems to be kind of awkward to me, hence the suggestion. Thank you.
Thank you. Anyone else? I'm going to close it to the public at this time. Anybody have anything else to say?
You want me to put the standard in?
I can do it. I mean,
Have at it.
my lip hurts, go ahead.
Okay, sorry. I didn't hear that. So, for the public's benefit, there was mention of they weren't sure what the standard was for a hardship variance. So, in requesting the variance, the applicant must show by reason of exceptional narrowness, shallowness, or shape of the property, or by reason of exceptional topographical conditions or physical features, or that there are extraordinary or exceptional circumstances, or that strict enforcement of the regulations would result in exceptional practical difficulties or undue hardship. So that's the standard that the board is considering the variance under.
Well, I would add to that.
Right.
Because even under the C1, they still need to show that it will not impair the intent and purpose of the zone planning and zoning ordinance and not have a substantial negative impact on the
It's a zone plan.
the zone plan, but it's also understood to be also on the neighbors. So it's, you know, so it weighs, there's positive criteria, negative criteria. The thing Craig read was more of the hardship standard, the C1 standard, but you still have to satisfy the negative criteria. So you have to consider the impact that has on other folks.
So, Mr. King, I do, want to reiterate the fact that, there is no backyard. It's 2.5 inches. I know my clients are trying to improve this property to make it more appealing to the eye. They're also trying to eliminate the problem with people parking out on the sidewalk, so they're trying to have designated parking. As far as the neighbors, I know they're very receptive to, if there's issues and they talk to them, they'll try to resolve those issues with them. Additionally, they can contact the police if they're having problems with noise or anything like that. The other thing I'd like to point out is if you look at these properties, and I think the ones off to the right are a part of a condominium unit that has a large pool that when you look at it from the top, and I believe there's some photos in there, you can see that pool, which is basically right next to my client's property. So as far as the light and sound and stuff like that that's occurring, it has been occurring. It's been occurring at that pool there, which is I guess, I'm not even sure how many units are in this, but I know it's a lot more than 4 bedrooms that utilize that pool. So I know my clients are trying to, you know, use this property. It is narrow, you know, yeah, in a perfect world, could you pick it up and move it? I don't know if that would solve the problem, because now you would have, you know, that pool area in the back right next to the other pool, but the people on the left side of it would have it right in their backyard. So I think this is I know Mr. Ross has said to me many times, he has clients that come in and say, hey, I want to do this, and Mr. Ross will say, look, I'm not doing it. And he'll call my office, and I say, well, if you're not doing it, I'm not doing it. I think it's a reasonable plan. I think it does meet the criteria for hardship based on the size of the lot. I think my clients have taken into consideration their neighbors and trying to make it that it is an improvement for the area, and it doesn't violate or conflict with any of the zoning. And again, it's the only one that we're asking for is the pool variance. Everything else is conforming.
The only thing I would add is, again, consider that although this
Hold on,
is...
wait 1 second. I just want to give you a heads up. If you're going to add new testimony, the public has been closed.
No,
Let me just say what I'm going to say. Give you a heads up. The public has been closed. We allow legal argument by the attorney as a closing. But if you're going to give more testimony, there's already someone in the public who's about to jump up, and I'm going to have to let them speak. So it's either open or closed.
I'm
You
done.
understand? Okay. So the public's closed. There's been no additional testimony. There's been legal argument. I'm going to clarify the standard one more time since it's contested. I want to add some stuff. Okay, so Craig read to you the hardship, and I would remind you that the hardship variance goes to it can go to the structures or the shape of the property. But also, there is negative criteria. I want to read that because I kind of mumbled it last time. Relief can never be granted unless it can be granted without substantial detriment to the public good and unless it will not substantially impair the intent and purpose of the zone plan and zoning ordinance. Also, there's been mention of hardship and how this came to be, so I just want to read a little bit on the concept of self-created hardship. The term undue hardship has been variously interpreted. The court made clear that it refers solely to particular physical conditions of the property as those are described in subsection C1 of the statute, which we just read. Hold on, I just want to get to that self-created hardship real quick. Oh, jeez, I just looked at it. Give me 1 second. It has some relevance. Ah, there it is, okay. Whether the hardship complained of by the applicant has been created by him, that circumstance may be considered by the municipal agency and may be a proper basis for finding that the positive criteria have not been proved and thus for denying relief. Note, however, that a prior owner or a testamentary divisor may have created the self-created hardship. It need not be the current owner. So what you're considering on that is where the house is located, they are arguing that that creates a hardship because they don't have a rear yard, they only have a front yard, and they can only put the pool where there's space to put it. And in that instance, it's the front yard. But the neighbors have provided testimony to indicate that a prior owner located the home in the rear because he wanted to have that space in the front open, okay? And although they didn't say it exactly, that's kind of what they're saying. Someone says you can move the house. So they're talking about the concept, they're all shaking their head, yeah. They're about the concept of self-created hardship. So that's part of what you're analyzing in reviewing whether the physical features of the property justify the request for the variance, okay? And they've given testimony, so this is one of those ones where it's in your discretion. Neither one of the things you would rule would probably be wrong in the view of a judge. So you're going to apply it. You've heard their arguments. You've heard the professional testimony. So that's the standards. Everybody understand that? Okay? Yes.
Question to the applicant. I think you testified you don't live there,
No,
and you don't go and occupy the building at all?
yes, we do.
We do.
You two physically occupy it
And our
when?
kids and our partners' kids, yes. We enjoy the property a lot.
Can I just, there's just, I don't, we just did a nice job setting forth a standard. I don't want to clutter it with irrelevant stuff. The fact that they rent it, irrelevant. Whether they live there, irrelevant. No matter what they tell you, okay, even if they say we live there and we are careful and we sit vigilant at the pool at 10 p.m. every night, irrelevant. They could sell it tomorrow and new people are there. The variance is not personal. You have to focus on the property and the zoning ordinance, okay? So I just want to, our record's clear, okay?
One question. Several people, times you've said there's no rear yard, there's only a couple inches. Am I looking at this wrong? There's a 25-foot backyard? But you've said, a couple people said.
The setback is 25 feet. From the building to the rear yard is 25 feet, 2.5 inches. So really.
There's a 25-foot backyard. That's all I need to know.
Yeah, but 2.5 inches, you can't do anything because you got to be outside of that setback. You can't put anything there.
That's not really comparing apples to apples. I mean, you're proposing a pool, and the pool has 10-foot setbacks. So you're required to set the pool back 10 foot from the rear lot line, 10 foot from the side lot lines, and it also has to be 10 feet away from the building. So, I mean, in reality, you probably could have a 5-foot skinny strip of a pool, but.
I'm just, there is a yard.
There is a yard.
There's a yard. That's-
The question was, so we don't get in trouble, is can we consider the testimony of the neighbors with regard to the hardship issue? Not only can you should consider all of the testimony, including the testimony, and it is relevant to the hardship issue, just as Mr. Ross's testimony that they could, putting it in the front, all the reasons he said to put it in the front yard, you should consider that testimony as well and judge its credibility. And
Yeah, that's part of the statute. I mean, it says without substantial detriment to the public good. I think we can consider that, yeah.
Yep. Okay, so the motion that I recommend being made is to grant the application. We always do it in the positive, so the motion is to grant the application for the variances of the variance on page 3, section 525-62A1C for a swimming pool in the front yard. That motion, subject to the conditions outlined by the board engineer. That motion is made in the positive, but how you vote is up to you. So yes, grants, and no, denies the application. Does everybody understand that? Any questions?
Yep and nope.
Oh, did someone make a motion? I'm sorry, Mr. Murray.
Somebody make
Do we have a motion?
Make the motion.
Do we have a second?
Second.
Motion by Mrs. Notch, seconded by Mr. Murray. Mr. Walsh?
No.
Mrs. Notch?
No.
Mr. Ledwin? No. Mrs. Werner?
No.
Mrs. McDade?
No.
Mr. Murray?
No.
Mrs. Hutchinson?
No. Sorry. We get so many applications for pools, and I will tell you that the biggest problem with them is the neighbors. One man actually even sold his house and moved down the street to get away from the pool, and then those people wanted to put in a pool.
Yes.
And again, I just wanted to thank everybody because, it was done, according, and I appreciate the public input. I think the public should provide input to all of that. It's part of the statute here. It's important to listen to what you say, and I want to thank you all for coming as well.
Good job, counsel. Sorry. It was a big ask. Yeah, you called it.
Good night, thank you. Okay. What do I do with that paper?
It's this one.
Shouldn't have bought that property, sorry.
Take a minute.
I thought you were thought you were bringing dinner.
My stomach's growling. I'm ready. Good night, folks. I'm used to being in bed by now.
Came here pretty soon.
I'm never going anywhere tomorrow. I've been up since 5 a.m. because I do the spay neuter clinic up at the courthouse. And I have to leave the house by 6 o'clock. Got back today about 3:30, ate something, fell asleep in a chair, and then went, oh my God, now I gotta go here.
I've been going nonstop since 6 this morning. My body doesn't adjust to that time thing. It takes like a month or two, and I'm still getting up at 5, 6 in the morning.
Taking a 5-minute my birthday. You know I'm spending my birthday. Thanks. Logan House. I know.
I need a birthday hour.
Birthday month.
Well, George and I, he's the 2nd of December, I'm the 10th of December.
Oh, so you spread it.
So it's like, goes all week. I make one cake, and I said it's for both of us.
We had a birthday today at 4 o'clock. Yeah. I go to the pizza man. He's got 2 people.
I'm the one, I speak with everybody. And we've been, he says, nope.
Happy birthday, Mama. Love Asher, my granddaughter. In the driveway.
Except for Teresa and Mary's kids. No, my mother's side.
Granddaughter says.
Mm.
And I looked at the driveway. These poor women. Is this an intervention or what?
Wishful thinking.
I like my glasses. Some green ones, yeah, I like that. Or turquoise or whatever you want to say they are. Oops is never good. Yeah.
Well, we used to think just put some wheels under it and you could pull it.
And I looked at that, and we could have done that, Michelle.
Why not give it a try?
And we're doing, at the same time, we're doing those courses, and we're doing that, which is gonna look amazing.
I know it's easy.
So our second and third floor, we look taking their drops off.
Yeah, well, for example, okay, but I mean, we shut our pool at 10 o'clock. In your home, you don't shut down the outdoors. And nobody wants on people who are paying.
Free dental for a year.
We understand COVID is they're parties. They're not people, but they're noisy. And that's.
Well, you
really
the
worse.
properties to the left of us, as well as my property, 2 properties in front, as well as in Victoria Walk.
I bang my head.
What property?
10 Jefferson.
What
where it's at. I went past the line, and I thought, well.
All right, everybody back? We are back in session.
Ready?
Applicant is Tony and Nicole Schultz at 215 Jefferson.
Thank you, member.
Troy.
Sorry.
It's okay.
It's a long night.
Long. Must be a D in the
Got answer to anything.
Thank you, members of the board. Madam Chair, my name is Robert Belasco. I'm an attorney at the law offices of Stefankiewicz and Belasco, located in North Wildwood, and I'm here tonight representing the interests of the applicant Troy and Nicole Schultz. The subject property is located at 215 Jefferson Street, and that's Lot 1, Block 1083, and it's located in the R3A zoning district, the medium-density residential district. The subject property is currently vacant. It's an undersized lot. It contains approximately 5,192 square feet, whereas 6,250 square feet would otherwise be required. The site was previously developed with a single-family dwelling, a 1.5-story single-family dwelling, which contained a total of 5 bedrooms. There was no off-street parking included on the property with the 5-bedroom unit that existed previously. The applicant is before the board tonight proposing the construction of a single-family dwelling which will contain a total of 3 bedrooms, and there are 4 off-street parking spaces that are proposed where none currently exist. I want to put this out there right away. We are located in the Historic District. We did receive conceptual approval from the Historic Preservation Commission back on February 14th of 2022. The off-street parking is not located in a front yard. It's located behind the structure, so I don't think we need to contend with those issues in connection with this application. We are before the board requesting 5 variances. They're C variances, one of which is tied to a pre-existing non-conforming condition, and that's associated with the fact that the lot size doesn't comply. It's an undersized lot we're dealing with. And the other variances are tied to setbacks, specifically the building setback that's proposed from Jefferson Street as well as from Benton Avenue. There's also a side yard setback and a rear yard setback variance that are requested as well. The proposed setbacks are larger than what previously existed on site, and Mr. Halbruner, who's here with me tonight, will provide testimony relative to what's proposed compared to what's required in this situation, and the justification which we believe exists here for the board to grant the relief that we're requesting. There is a retaining wall proposed on site as well to address issues associated with flooding. This property is prone to flooding. It's located in a flood district, a flood area, as most of Cape May unfortunately is. And essentially, our proposal tonight is to orient this structure towards Jefferson Street. The structure will be 2.5 habitable stories. There is not an issue with building height. 35 feet is required, whereas I believe we're at 30.4 feet total. And we comply with lot coverage, floor area ratio, and essentially every other condition with the exception of the variances which I identified earlier and which Mr. Halbruner will testify to. I do have 2 witnesses here with me tonight, Troy Schultz and Mr. Halbruner, and I would ask that they be sworn at this time.
Our engineer remains under oath. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Madam Chair, I intend to start with Mr. Schultz, but I know Mr. Halbruner's been before this board before, and I would ask that the board accept him as an expert. Thank you.
Engineer and architect.
Yes, thank you. Mr. Schultz, you purchased this subject property approximately how many years ago?
1.
And when you purchased the property, what existed on site?
There was an existing single-family dwelling that was in very poor condition.
And you have since demolished that structure, correct?
Yes.
And you did so with the approval of the Historic Preservation Commission?
Yes.
And it's fair to say that this property, while it's in the Historic District, it's a non-contributing structure, correct?
Correct.
Now, with respect to your proposal before the board tonight, you're proposing a single-family dwelling, correct?
Yes.
And how many bedrooms are proposed?
3.
And how many off-street parking spaces are incorporated on site?
4.
How do you intend to utilize the property? Like, what's the purpose? What's your goal? How do you intend to use the property? You intend to rent it, occupy it?
No, second family home for us. for my
Understood.
family.
And there was a question identified in the board engineer's report with respect to some storage space that's proposed on the second floor. Do you have any intentions of ever converting that into habitable space?
No.
What's the purpose of including that storage space on the second floor?
Simply storage. much of an attic. We had roof line down, and I know there's a lot of flooding here in Cape May, so we don't plan on storing things there, so we really didn't have that much storage. So it's just like storage area.
Now, you understand that the concern that's raised is that if that's converted to a bedroom or livable, habitable space, it would increase the floor area ratio to a point where a variance is required, correct?
Correct.
And we discussed a potential condition of approval that we were going to propose to the board tonight. Would you confirm that you would be amenable to a condition of approval that that storage space would be exclusively used as storage and would never be converted to a habitable area in the structure?
Yes.
And, sorry. I don't have any more questions for
Excuse me,
Mr.
Can I just ask, what's the square footage of that storage area?
I can have Mr. Halbruner testify to that when I get
Okay,
to his
that's fine.
testimony.
Thank you.
But I don't have any more questions for Mr. Schultz unless there's questions from the board.
Anybody have any questions? No, not yet.
I have one. I'm just looking at some of the pictures and where you were demolished the house. Also, the trees were taken down, and now it's an empty lot. Was Shade Tree Commission?
We did receive approval from the Cape May City Fire Department. We did receive approval from the Public Works Department and from the Shade Tree Commission. The Shade Tree Commission.
Take the trees down?
Well, the Shade Tree Commission, the approval that I have is approved. There's no lot, there's no trees on the lot. I can't speak to whether or not they authorized it
Pictures-
before.
Pictures in a packet that there were trees on that lot.
There's a requirement, whenever they're building a new structure, that they have to provide a landscaping plan, so that's a recommendation in my report.
Okay.
And we'll get to Craig's report later, but for the record, we have no objections to the conditions and requirements that are outlined therein. And with that said, Mr. Halbruner, can you describe the existing conditions associated with the subject property?
Sure, it's going to be kind of a two-part answer. The existing condition as it sits today is, as you just heard, a vacant lot. Approximately less than 1 year ago, the former conditions, and that which I try to compare what we're proposing to do, what used to be there, was, as you heard earlier, an older, rather poor condition, 1.5-story single-family home.
Yeah, your mic.
Is that better? Should I start over again, or are you?
Yes.
Okay. Okay.
Mr. Halbruner, can you describe the existing conditions for the benefit of the board, please?
Absolutely, and this will be answered in two parts. The first part is the condition as it sits today is a vacant lot. It's been demolished of all structures and vegetation from what was there about a year ago, which was a 1.5-story home built in probably the 1950s that contained 5 bedrooms and was in pretty poor condition. That was demolished with HPC approval roughly 10 months ago.
Now, with respect to the lot in question, this is a corner lot, correct?
It is. It fronts on both Jefferson and Benton.
And it's an undersized lot as well, correct?
It is. In fact, it's 52.5 feet wide, but the total area is only 5,192 and change square feet. Compare that to the minimum required for the zone, which is 6,250. We're significantly challenged by having a lot that is well undersized.
And with respect to the corner lot, because we contain frontage on 2 streets, we're required to comply with a more significant building setback, correct?
Correct. You're actually subject to front yard setbacks on both of the public roads. So compare that to a 20-foot setback required from the public road compared to an 8-foot setback necessary from an interior lot. We're, again, taking an undersized lot, and then we're further hampered by having a more aggressive front yard setback requirement.
And with respect to the proposed conditions, can you describe the site plan that's proposed, the development that the applicant's proposing before the board tonight?
I can, but there's 2 particular existing features that I think are worth pointing out before I jump into the proposed condition, and that was the orientation and siting of the original building. And it'll become germane when I start talking about the setbacks that we're proposing. The original building was set back both 4 feet from both Jefferson and Benton. Now, truth be told, that was to the stairs. The building was set back a couple feet more than that, but the front yard setback of the original building was 4 feet from both Benton and Jefferson Avenue. Jefferson Street, Benton Avenue, excuse me.
I'm sorry, I don't mean to interrupt, but you're saying it's 4 feet, the structure was 16 feet, though, right? It's 4 feet to the stairs.
The testimony was 4 feet to the stairs, correct?
To the stairs.
But to the structure, to the house?
The actual numbers was the covered porch, which is really the
Okay.
first element would be 11.3 feet off of Jefferson originally, and the stairs were not dimensioned on the survey. I'm estimating them at 4 feet. Off Benton Avenue, it was 4 feet to a bay window, 6.1 feet to the principal building of the wall.
And as far as what's proposed, can you take the board through the layout of the structure and how it relates to the setbacks that are proposed versus what's required?
Yes, the new building is virtually centered on the lot between the rear or side property line and Benton Avenue. And its physical face, its street presence front is facing Jefferson. And then the rear, I'll call it, which is down Benton Avenue further, is where we are providing 4 new parking spaces. The building itself it's really 1.5 stories over an elevated, at-grade garage storage, elevated area, elevated primarily to keep us out of the flood zone. It now, as proposed, is a total of 3 bedrooms. Let's compare that to the original 5-bedroom home, and we're reducing that count by 2, which is a pretty significant decrease in the number of bedrooms.
Go ahead, I apologize.
The siting of the building, it sounds bad when you say we need setback variances from all 4 sides. But let me explain that, and it's not nearly as bad as what it sounds. If we start with the side yard setback, the minimum required side yard setback in your ordinance for this zone is 8 feet. The building wall that we propose is in fact 8 feet. We have a 1-foot overhang, and your ordinance actually takes a setback to the roof overhang, and that is 7 feet. So because of that 1-foot encroachment of the roof overhang, we are looking for basically a 1-foot encroachment variance within that side yard. But the principal wall is in fact at a conforming 8-foot setback. Similarly, if you look at the rear yard setback, the minimum required is 25 feet. It is 25 feet, in fact, to the wall. Our roof overhang encroaches 18 inches on that side, so we're seeking a variance for 23.5 feet for a rear yard setback. So there's 2 variances that are absolutely necessary. I'm not saying they're not. But the reality of it is, the physical wall, the mass of the building is at the conforming setback. We have the roof overhang that encroaches that little bit. In a similar vein, if you look at the setback from Jefferson, 20-foot front yard setbacks required. Our stairs are 19.73 feet. Our stairs are just about conforming. The building and the covered porch are well beyond the minimum setback. So the mass of the building is really conforming at the 20-foot setback. Let's remember, this is the same setback or same street that presently has a 4-foot setback to the stairs, plus or minus, and a 10-foot and change setback to the covered porch that's there. So the building, as we're citing it, does require a setback variance from that road, but we're set back significantly more and almost conforming compared to what was there previously. The last setback variance is of a Benton, and here, again, 20 feet would be required, and we're proposing 8 feet. We're proposing essentially to treat this as if this were an interior lot. That results in a building that has of adequate width to be functional. It's of a building size that is comparable to the neighborhood, but does in fact require that front yard setback from Benton. Let me make sure I got those numbers correct. We are 8 feet to the building proper, again, 7 feet to the roof overhang from Benton. I will once again remind everyone to compare that to the existing setback, 4 feet to a bay window, 6.1 feet to the wall of the existing building. So we are seeking the variance. We are pretty dramatically improving the setback from the conditions that existed prior to the house being demolished, and will result in a pretty significant improvement to the view corridors up and down Benton Avenue.
Mr. Halpern, do you think the fact that there are 2 fronts in this situation, does that present any sort of practical difficulties in complying with the ordinance, given the fact that this is also an undersized lot in the R3A zone?
Yeah, exactly. I know in the last application, the board was reminded of the hardship definition, and I think this one falls very squarely into that. We have a lot that is undersized. We don't have the ability to acquire more lands to make it conforming, so we are already at a disadvantage by having an undersized lot. We're further disadvantaged and a hardship further created by the fact that we're subject to 2 front yard setbacks. The resulting building envelope, if we were conforming, would be 24 feet wide. We'd be allowed to have a building that was only 24 feet wide. On this small of a lot, that resulted in a building that really is impractical. So there is a hardship upon the applicant that certainly is not self-created. He didn't create the lot it is what it is. His predecessor didn't create the lot. We're handcuffed with it, so the building design that was done in a manner that does in fact require these variances that we're seeking. However, if you look at it in the totality, the proportions of the building, the size of the building in terms of its floor area ratio, the height of the building, I mean, we didn't talk about that, but the height of the building is 30.4 feet.
And how high could the building be?
It could be 35 or even 40 feet with a steeper roof pitch. So, we started looking at some of the negative effects that may result from these variances. If you look at the purposes of setbacks, well, there's really kind of twofold. One is to make sure there's adequate light, air, and open space for the public. And the second one is to make sure that there's plenty of room for emergency personnel to get around the building in the event they need to. And the situation where our side and rear yard is virtually conforming, so that's certainly not a substantial deviation. Where we're most asking for the biggest deviation is on Benton Avenue, but it's a public road. So the light, air, and open space certainly is not constrained, especially when you consider that it's greater than what was there prior. And certainly it's not a problem for emergency personnel to get to it. It's on a public road.
So fair to say there's no direct impact to any neighboring property associated with the Benton Avenue setback?
Not at all, not at all. And the things that you would normally be concerned about when you talk about seeking side yard setback variance, I think don't really apply here. So you couple that with a hardship we're faced given the constraints of the lot and the double front yard setback, it results in a challenge that I think the proposed development satisfies in a very positive manner. In fact, there are a lot of positives that come out of that. I kind of jump in the negatives. But you start looking at the positives of this development. First of all, we're taking what was drastically non-complying setbacks, and we're making them, for the most part, compliant, or at least more compliant. We're taking a building that is not oversized. You start talking about developing an undersized lot, the potential is, well, it's going to get too tall, it's going to get too massive, it's going to get too big. Clearly not.
Do we exceed lot coverage?
Our lot coverage is less than the maximum permitted. Our floor area ratio is less than permitted. Our height is much less than is permitted. So the proportion of the building as it's designed is appropriate for the undersized lot. And that actually results in a substantial benefit, I believe, to the neighborhood. We're creating 4 parking spaces. No parking spaces exist for 5 bedrooms. So where none existed, we're now proposing 4. For 3 bedrooms, we would be required to provide 2. We're doubling that.
Now, with respect to the applicant's proposal before the board tonight, do you believe that the proposal, the design of this structure is adequate or appropriate given the size of this lot?
I do. Yeah, I think the proportions of it are appropriate.
Now, with respect to, we're asking the board to consider this under the C1 hardship criteria, and I think you've testified as to the basis upon which the board can find a hardship in this situation. We're also required to address the negative criteria.
Correct.
Do you believe that there are any substantial detriments to the public good in connection with this proposal?
I really struggle to find a single detriment to it, let alone a substantial detriment. So no, I don't believe there is a detriment.
Is it fair to say that one could argue that there are a number of positives that come along with this proposal that benefit the public good?
Absolutely. I mean, the fact that we have a building that is less in mass and size than was permitted is certainly a benefit to the neighborhood. The fact we're adding landscaping and street trees which don't exist is certainly going to be a benefit. The fact we're providing parking where none existed is certainly a benefit. And we know with those positives, it starts to tie into some of the purposes of the municipal land use law that this application does in fact advance.
Can you identify various purposes, since you've brought it up, that you believe
Sure.
are advanced by this application?
Sure, and before I jump into that, there's probably one more fact that we have probably not mentioned we haven't talked about yet, and that is the fact that this building will be fully compliant with all the flood damage prevention requirements. The prior building was below the required design flood elevation. So by replacing the former building with this new building, we are advancing one of the purposes of municipal land use law to secure safety from fire, flood, panic, and other natural man-made disasters. Despite the fact that we are seeking side yard setback variances and front yard setback variances, it sounds counterintuitive, but we're actually providing adequate light, air, and open space. We're increasing the setbacks from that which existed before along the public roads. We also have a building that is less tall than what the ordinance would otherwise contemplate or allow. So I think that we're providing, one of the purposes of providing adequate light, air, and open space. The providing of 4 parking spaces where none exist, and actually providing more than what the ordinance requires, advances another purpose, which is to promote the free flow of traffic. And lastly, we had a building that was in pretty serious disrepair. We're replacing it with a brand-new building that is much more aesthetically pleasing, and in doing so, we're promoting a desirable visual environment. All those are purposes of municipal land use law that this purpose of this application advances.
Now, we talked about the public good and any substantial detriments to the public good. Do you believe that this proposal in any way impairs the intent or purpose of the city's zone plan or zoning ordinance?
I don't. You know, the purposes of the setbacks I covered, and I think I described how, despite the fact we're seeking the deviation from that, we're advancing the intent.
And with respect to the setbacks, now obviously the Benton Avenue setback is a little bit different, but the Jefferson Avenue, or Jefferson Street setback, the rear yard setback, and the side yard setback, we conform to the structure, correct?
Correct.
So the eave, or essentially the overhang, is what the variance is tied to.
Correct.
And approximately, how high up off of ground level is that overhang?
The eave itself is going to be somewhere in the order of about 25 feet above grade.
And you think it will have any measurable impact, or would be noticeable by any member of the general public? Would it be obvious that we don't comply with those setbacks that are required in this situation?
Absolutely not. They're going to perceive the wall to be the setback to the building. In fact, there would be a deleterious effect to the streetscape and the aesthetics of the building the public would notice if there was no overhang.
I don't have any other questions for Mr. Halbruner. If the board has any questions, we're happy to answer them.
You mentioned a retaining wall.
Yes.
Then in the HPC, line 4, paragraph B, it says hedgerow instead of retaining wall.
So this was a conceptual approval. Obviously, we'll have to go back to the,
I'm not going to start that again, right?
yeah, no.
No, in fact, on the issue of the retaining wall, I don't want to steal Mr. Hills has done it too much, but he's correctly pointed out that in a couple of areas, the wall as proposed is slightly higher than 24 inches. We will amend that so that it's not more than 24 inches, which is one of your ordinance requirements.
Which would include also a hedgerow. You would have to make sure that that's not in the sight line?
Correct.
Okay.
So the wall will be 24 inches?
Correct, well, not more than 24 inches.
The wall will go around the entire perimeter?
Not the entire perimeter, but a large part, all of the Jefferson Avenue, Jefferson Street, and most of the Benton Avenue. We step it down where we come in for the parking.
When, will the parking be at grade, or will the parking have to go up?
It grades, it slopes up, but
How high will that be?
above existing grade, forgive me, as I,
Yeah.
we have a grading plan that'll describe that, if you bear with me a second. Existing grade in the rear of the property, at the back of our parking spaces, hovers around elevation 3.0. We're proposing right around elevation 4. So we're going to be putting about a foot of fill in where the parking area is.
What is this, the ground floor underneath? What's under there? Is it just like a cemented
Here it has a door,
space?
yeah.
It's just space? Okay. And it's got the flood vents here,
It's not a habitable space.
not habitable, but
Correct.
What is this, oh, I'm sorry.
that's okay. Are you doing anything, like if water seeps in there, is there any kind of a system to, for that water to get back out?
A
Like,
pump?
Besides,
Sump
besides the, I'm just thinking about my own house.
No, the house, we actually elevated it up. I'm not sure about the front, but there would be drain tile that ran around that would be able to, so that water didn't get in there.
Real quick, on the issue of habitable space, I apologize. I neglected to ask Mr. Halbern to answer Ms. McDade's question. Square footage of this proposed storage room?
Oh, thank you. I'm estimating, because it's not annotated on the plan, but I'm estimating at around 600 square feet.
It's 600 square feet of storage on the second floor.
Correct.
600 square feet.
Correct.
That's a lot of storage.
There's no attic proposed here because of the height issue. And like I indicated, we'd be happy with a condition of, we would agree to a condition of approval that this is never converted to habitable space.
But it could never be converted while you own it. The next
could-
owner down the road.
We could do a
would very
deed
easily
restriction,
convert
I
that to
suppose,
double
but I mean, that,
Yeah, I never know how that gets enforced, and after you do once they get a CO, how do we get back in there to check that? Who knows?
Well,
I mean, I never know how that works. I mean, yeah, the deed's the only way to do it, to make it binding on the next owner and all, but
But it can't be
There's no-
enforced, right?
They check
Basically,
every
you're saying
time
it
you
cannot
sell
be
something.
enforced.
I mean,
Well, it can be
it's on the honor system mostly. I mean, how do you really?
And it can get enforced. I mean, anytime there's an inspection of the property, I mean, property changes hands. I mean, I've seen it in other municipalities where an MLS listing references a fourth bedroom on the property. The zoning officer catches wind of it, they go out, they conduct an inspection, and it's a notice of zoning violation that's issued at that point in time.
Does KB have a continuing certificate of occupancy? Do they check it with each title transfer?
I don't think so, but
I don't know if you do or not.
if it's not renting it out, there's no reason for them to go in there. So you can have it for 20 years. and I don't know, Craig will address it, and we have a definition, and he'll,
Can I just ask?
I think if we're gonna do it, there should be something, a resolution doesn't cut it, because it doesn't restrict future owners. It needs to be a deed restriction, and that's the only way to make sure it's
Right.
always enforced.
And I think that the applicant is amenable to the deed restriction.
Can never be, it would be on notice, any future, any objection.
Can I
I
ask?
always point it out whenever they're close to exceeding the floor area ratio, and then they leave that unfinished space that is easily converted to habitable space.
Where are they in the, I couldn't, it wasn't on the, I didn't see it on the chart, the floor ratio, not on your chart.
So-
Floor ratio, it is basically at the limit.
They are at .394, where .40 is the maximum allowable.
Right.
So whenever we're in that situation, I always flag it in the report.
Can I ask what this temporary guardrail is on the back rear elevation? French doors leading to,
nothing.
Nothing?
It's just that little grail.
like a Juliet balcony or
It
something?
looks like a Juliet balcony. Forgive me, I'm not the architect for
That's
this,
okay,
for this
sorry.
application.
Temporary means
I'm interpreting
something
them
else
as you
going
are.
Is a deck planned?
No.
So you're putting in French doors just to, okay.
Yep.
It just looks like there's something there.
Okay.
I always wonder about those things. I'm like,
Yeah.
why did anybody do that? It's like, you know, like, you put in these beautiful French doors, but
They're going nowhere.
don't go out there.
Okay. Ask and answer.
Almost like the next person buys it and they want to spend it. Okay. Craig, do we have your report?
Certainly. Summarizing my October 17th, 2022 memorandum of review. This is a project located in the R3A Medium Density Residential District. The applicant has demolished the existing single-family dwelling and has proposed a new single-family dwelling, 3 bedrooms, 2,046 square feet of habitable area is proposed. With regards to completeness, item 18, I recommend be provided as a condition of approval. Item 27, I just looked at the plan and I just saw something that I missed earlier. Items 27 has been provided on the plan. The utilities are shown. So I did recommend deeming these application complete. To summarize the variances that are being requested, this is an existing undersized lot. 6,250 square feet is the requirement in the district, where 5,192.25 square feet is existing and proposed. With regards to the structure, Mr. Halbrunner went over the variances. This is a corner lot. It has frontage on both Benton and Jefferson Avenue. The setback requirements from those streets is 20 feet. 7 foot is provided on Benton Avenue, 19.73 is proposed on Jefferson. With regards to rear yard, so this has 1 rear yard and 1 side yard. The rear yard requirement is 25 feet, where 23.5 feet is proposed. Side yard has a setback requirement of 8 feet, where 7.5 feet is proposed. One typo in my zoning table, the parking requirement for 3 bedrooms is 2 parking spaces. They've proposed 4, not 3. I indicate 3, but there's 4 physical spaces that are provided. Okay, so I touched on the variances. I'll just move on to the general review comments. These should be conditions of approval. Already talked about item number 1, which is just providing a signature block. Item 2 is, I don't know how the board wants to handle this, but confirm that, the applicant should confirm that the unfinished storage area on the second floor is not to be converted to habitable space. That would trigger a floor area ratio variance. So we're just putting it out there, letting them know that they're right up against it, and that if that space is ever converted, creates a use variance situation.
What distinguishes habitable space from non, under our ordinance, why doesn't that count? If it's, I thought it was.
So it has to be finished, and it has to have a floor-to-ceiling height of 6.5 feet. So that leaving it unfinished essentially keeps them out of that situation. That's what happens. They don't finish it, and then it comes back and they finish it, and it becomes a non-conforming situation. So I don't know how the board wants to handle that with a deed notice or deed restriction or.
I spoke to the applicant. I mean, we're good with the condition of approval, and if the board prefers a deed restriction or deed note, we'll file that as
What are
well.
the consequences if they do it?
If they do what?
Suppose 20 years from now, we find out that they had 2 bedrooms in that area for the last 20 years, what are the consequences?
Well, they get violated, and they would have to come back before the board. I mean, they'd be hauled into court, there'd be a summons issued, and, I
What
mean,
happens for the last 20 years that they used it?
nothing.
Nothing.
I mean, if I'm being honest, I mean, I'm not going to lie to the board. I
You
mean,
haven't noticed, I'm not a fan of like big storage areas on plans, because you just don't know what it is, and it comes back to us that like, well, you know, like.
well, I think the testimony here, I mean, makes sense. I mean, there's no attic space here. I mean, he's trying to elevate this house to deal with a flooding issue. He has no intentions, as he's testified to earlier, of converting it to habitable space. We've proposed a condition. We're okay with a deed notice as well. Anytime this structure is inspected, or if it's ultimately sold at some point in the future, and it's determined that this thing was illegally converted, well, my client's going to have an issue with the future owner of the property, and likely going to face a lawsuit if it's illegally converted in that individual's notice. So there is recourse available in this situation, but it's his testimony here tonight that he has no intentions of converting that space to habitable space.
No one's
And-
saying that he would do it, but, you know, houses change hands here.
I understand.
Constantly. And the next tenant or owner, you know, who knows, could very easily.
But your position is, since you're below the height, you don't have an attic, so this is like your attic, but.
It's storage space, correct. And I mean, at the end of the day, you know, individuals you're allowed to have storage space at a house, and I do appreciate the board's concerns, and Mr. Schultz and I discussed this before tonight, and his representations were to me, and his representations on this record tonight under oath before this board are that he has no intentions of converting this. He has no space. You can't store space in the basement because, or the ground floor, because of the potential concerns for flooding. I suppose we could redesign the structure to add an attic on, but, you know, that likely results in the need for a building height variance. We thought this was the best alternative.
So we do know, like, if a house, when a house is sold, and we've had a situation, like, when a house gets sold, somebody from the office, the zoning or whatever office down there, they have to come out and inspect that property according to whatever these plans are. And they look to see if anything has been done.
You don't have to persuade me.
I'm just saying, that's
Things
what
can
happens.
be sold every year, every 30 years. I mean, listen,
It gets caught.
I'm not new.
My understanding is that the city of Cape May has a certificate of zoning use compliance requirement in the ordinance, that when a property is sold, and if there are some exceptions, because we've adopted a similar ordinance in the borough of Wildwood Crest and in the city of North Wildwood, but when a property is sold and it changes hands, the construction office or the zoning office goes out, inspects the property, confirms the use that exists, and they issue a certificate to the future owner of that property. You're buying a conforming single-family home, or you're buying a non-conforming structure. This is what's approved. So they're on notice of what it is that they're buying. And if there is an illegal conversion, to your point, Madam Chair, it's discovered at that point in time, and ultimately an issue that the owner has to deal
Usually
with.
happens after that sale.
There's one that's.
It's after the first sale, and then that new buyer says, oh, look at this space,
Mm-hmm.
I'm going to convert
Greg,
it.
I think you were the board engineer the whole time I've been here, so you remember the property was on Lafayette Street that sold. There was a whole nother structure in the back, another building.
Yeah.
that nobody knew about until it's sold.
It's amazing.
My
when-
son used to be friends with the kid, and I'm like, did you know that there was another house in the back? Oh, yeah, there was always, Mr. So-and-so, they built that. But it gets caught, is what I'm saying, eventually. They don't, not everybody's building another house, but that was pretty blatant that they did that.
What I found is that the only place it appears is in the resolution of approval, and then most buyers don't even bother to pull that. So the only way that people know is usually a deed notice or deed restriction.
And that'll come up during the title search.
Right,
And then they're on.
that's, the title search is what flags it.
It's trust, you gotta trust that, you know. Not
So,
have more kids.
anyway, however the board wants to handle that, we'll let that for further discussion. Item 3, I just point out that this is a corner lot, and they're required to comply with the site triangle requirements. We had concerns with regards to the retaining wall. They're also required to provide a landscaping plan, any new structures, they cleared the lot, so that has to be provided, and that landscaping must conform to those requirements.
Should have that on that plan set.
I'm sorry?
The landscaping plan is
There is
included
one?
with the plan set, yeah.
Okay.
We'll deal with that afterward, but
Gotcha, okay. So we'll review that, and it also has to be approved by the construction zoning official. Street trees are required along the frontage, so those should be adjusted so that they do not interfere with the clear sight from the intersection and driveways. Item number 5 is the retaining wall has a limit of cannot exceed 24 inches in height, so we've asked for a revised grading and drainage plan to be provided. Item 6 is our standard requirement that after they start providing the improvements, if these improvements change the stormwater runoff patterns on site or the adjoining sites, the grading and drainage plan is required to be submitted for review and approved by the board engineer. 7 is the requirement that this new sewer and water services be approved by the city sewer and water department. 8 is our standard condition that sidewalk adjacent to the subject site be replaced to the satisfaction of the engineer. 9 is the standard condition that they have to comply with Chapter 258 Flood Damage Protection Code for new construction. Item number 10 is the requirement that they provide the inspection escrow, and the certificate of occupancy is tied to the acceptance of improvements. Item 11 is compliance with the Shade Tree Commission requirements. 12 is the project is located within the historic district. HPC final approval, evidence of that is required. You did say you got conceptual, right?
Correct, yes, on February 14, 2022.
Okay. Compliance with all other state, county, and local approvals is item number 13. Comply with any and all applicable affordable housing requirements at the time of approval or issuance of building permits as applicable is item number 14. And finally, should the board grant approval, the applicant is required to revise the plans consistent with the conditions that the board sets and submit 6 sets of compliance plans to the board engineer for review and approval.
And we have no objection to complying with all of those conditions and requirements outlined in the report.
Thank you. That's a summary of my report, and I'm happy to answer any questions.
Anybody have any questions? Can we open it to the public at this time? Anybody within 200 feet that would like to speak?
He's ready for
All
you.
right, sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Will you
I'm
please say and spell your name? and-
Arthur Dorman, D-O-R-M-A-N-N. And our family owns the property at 902 Benton, which is right next door. Want to point out, I don't want to question anybody's integrity, but we did receive a certified envelope with nothing in it to start. The second thing is, somebody said there was no trees on the lot. I've trimmed those trees myself. The older people next door weren't able to handle it. I trimmed those trees. There was trees all along the borderline, including the most prolific fig tree that I've ever seen in my life. There's disingenuousness right now in the testimony. When I looked at their plans, the height of the property, there's an arbitrary 11-foot that is where they pick the height of the property that they're building. There's no actual height to ground level. So you can't even tell what the actual height of the building is. When they say that the house was 4 feet off I would like to see documentation that it was 4 feet. I've walked along there a lot of times. That house was much more than 4 feet off. And if there was anything at 4 feet, it may have been a small bay window that stuck out. They've increased the footprint tremendously. They say that this is in compliance with the neighborhood. The neighborhood is mostly houses between 750 and 1,500 square feet. This house on their listing says 4,400 square feet. Okay, when you look on their cover sheet, there's so many things that are hard and difficult for you to follow when you're looking at this print. We already have a major water problem in that area. My parents, years ago, we put an addition on the house. We were required to put an underground drain system in to mitigate the water on the property, which has done a fairly effective job as far as taking care of the surface water. But now they're going to raise the area surrounding it, including the area right adjoining our property, because their theoretical backyard is our side yard. So they're going to raise that. They're saying they're going to raise the parking over a foot, which is going to create more of a water problem on our property, because water, that acts like almost like putting a water tower up in the air. When you increase the ground level, you increase the water saturation point, and it's going to force down and out towards our property. I can't do all the calculations just, based off of their drawings, but there's a lot of ground cover. The front porch, they've increased, even though they're saying they really haven't increased, and that the stairway came out a lot closer on Jefferson. They've now turned the stairways the other way, so it's actually a much more imposing structure at street level. And if you look at their drawings, you've got sheer walls that are 30 feet up in the air, that are 5 feet off or 7 feet off the sidewalk. When we applied for our variance, we tried to get additional. We wanted to put just a natural flowing stairway down off the front porch that would allow, it's a much more appealing look from the curb. It's much more pleasant for people to walk by and see up, onto a porch than see the side of a stairway. We were forced to turn the stairway sideways, and we were told because of the setbacks. Even though they were closer to the road, we were the very next house within 20 feet of it. We had to adhere to the Benton setbacks. And we were told at the time, if they ever do anything with that corner house, they'll be required to have the setbacks too. That's what we were told when we went to the, for our variance. It appears to me, I mean, I'm sure the gentleman, it means what he says, that it's a 600-foot storage area. But if he didn't have that storage area and were to incorporate that space, he could have a smaller footprint and have the same size livable space in the house. It doesn't have to have that 600-foot. There's no advantage to it. It's only a headache for everybody involved. It makes a bigger structure. It makes more a larger covering of the ground, and more water mitigation has to take place. Let me see. The 4 parking spots are basically the entire backyard, which probably is fine. I don't know, it's just that's what we're going to be looking at now is those 4 parking spots. When we did our house, we asked for a double curb cut, which you're going to require for the 2 parking lanes that they have. We were told we could only have a single curb cut for the property. Now the next door neighbor, who's going to take parking off of our street by making a double curb cut, because we were told putting more than a single curb cut is taking away from parking on the street, and parking's a minimum. So making a double curb cut like it's going to be required here is going to take additional parking away on our street. I don't,
Why is it going to have a double curb cut?
I'm sorry.
Aren't they stacked parking?
He has, on his proposal, on the drawing, he has two drive lanes, 2 cars each. I'm assuming that's, it's long enough for 2 cars, one behind the other in both. So, you know, it's pretty much my notes. I hope I was loud enough for you to all hear.
Yes.
But the biggest issue we have in that area is the water. And raising the level of the ground around us is going to create water issues for all the surrounding, you know, for the houses on either side. But
Well, I was going to say, Craig, can we address that?
Yeah, we've asked for a drainage plan.
It's in,
So the retaining wall is actually going to stop water from shedding towards your property and direct it towards the street.
Okay, we weren't allowed to dump it on the street. That's what we were told at the time. It
So,
had to
no,
be,
it's actually-
had to be mitigated on the property.
No, so your drainage actually goes from, was that Benton to the rear of your property? And his is going the opposite way. That retaining wall is going to stop any water from shedding onto your property.
Well, the retaining wall isn't on my side of the property, according to what I saw on the print. The retaining wall is on the side yard for the house on Jefferson. It's not on, we're on Benton. We're 902 Benton, so
It's next to.
we're next to the driveway, which is being raised a foot.
it
And the
runs-
driveway is going to be hard packed. It's going to run right off of there.
This shows,
Correct, the grading's on that plan.
yeah, is there not a retaining wall that runs along the driveway?
There is.
Okay, that's what I thought, so.
It shows grade.
The applicant's confirming that.
Okay.
Is there an underground drainage that goes down and goes into the sewer,
Into the street?
No, it's surface runoff directed towards the street.
right to the street?
All of it is swelled to direct water away from adjoining properties into the adjacent streets. As what is required. There is no runoff being directed towards this gentleman's or any of the adjoining properties.
Any of the other properties? I know that's really important, that we always try not to,
No, I know, I understand that, we had to put a drain system in, so it was,
I get it from my next door neighbor. It all comes underground though.
pardon?
My next door neighbor's comes underground and into my house,
Okay.
into my basement. So I can really,
That's what happens. It follows the clay layer there, and yes, and that's what I'm afraid is going to happen here. More of it's going to come out from under that property. How deep is the retaining wall set in the ground that it's going to stop water from traveling along? Is the retaining wall 3-4 feet deep in the ground to get through into the clay layer to make it impervious? Or is it just going to be into the ground and allow the water to sink down into the ground, hold the water on the property, sink down into the ground, and then come out along the clay layer and affect the neighboring properties?
There are multiple issues at hand here in his statements regarding drainage and clay layers and the like. Here's an engineering reality. We are filling along the edge of the perimeter approximately 1 foot.
Pardon, can you speak up, sir?
Yeah.
Sorry, is this better?
Yeah.
Okay, I'm
Go
sorry.
ahead.
We are filling along the edge of the property line approximately 1 foot at the most. That's not enough to cause groundwater mounding of any magnitude whatsoever. The surface runoff we have, it's not going to percolate into the ground as much as it's going to run off the ground and into the public streets. there's going to be.
Well, you're proposing,
Excuse
you're
me, sir.
proposing a
We kinda do-
driveway
sir,
that
sir,
has,
we kinda
it's
do-
permeable.
sir, We kind of do it one at a time, Paul.
I'm sorry, I'm sorry.
The design of the stormwater runoff from the grading is specifically designed to not have an adverse impact on neighboring property. There may very well be, and I'm looking at the grades on his property, he has a grading problem. But that's not, he does, yes. The neighbors do. But it's not as a resultant from runoff that's going to come from this development.
But we don't have a water problem now. I'm afraid of having one in the future.
Well, let me say this. The city has an ordinance that deals with stormwater management. We've provided testimony relative to the efforts that we're going to take to address the stormwater management. We've also agreed to a condition of approval that will provide whatever calculations or documentation is required to satisfy the board's engineer to ensure compliance with that ordinance. Now, the ordinance requires that the stormwater management be maintained on the site, be contained on the site, and that it doesn't impact neighboring properties. We have a retaining wall proposed. We're grading this property so that it's pitched towards the roadway. That will be assured and dealt with and reviewed by your board engineer to confirm compliance. So I understand and appreciate the concerns, but there are safeguards in place in the city's ordinance and with the city's professionals to ensure that there is no adverse effect to neighboring properties associated with stormwater management. I mean, the fact that there's a retaining wall proposed in this situation is going to have a significant impact. Actually, could you confirm that the inclusion of a retaining wall will have a positive impact on drainage issues? I can't testify, so.
Sure. By having the retaining wall, it's allowing us to alter grades on our property to ensure that they are sloped so that all runoff goes away from neighboring properties and into the public street. Without those retaining walls, we could not do that.
Craig, isn't there an ordinance that's currently being proposed to council that talks about nuisance runoff?
There is, but it's not on the books yet.
It's not on the books now, but could you just speak to that for, a minute, about what will be available in the future to,
Yeah, so, and it's not approved yet, but
Right.
they're contemplating a grading and drainage requirement as well as a stormwater storage requirement for certain types of applications. This would qualify if that ordinance, the draft ordinance that I've reviewed is passed. There's also a nuisance portion of that ordinance where if you're shedding water onto someone's property, the city has the ability to require you to mitigate that situation.
it was before council as a first reading, and, it's looking to address, future concerns so that if this, for some reason, my understanding is that if this proposal for some reason did not satisfy and created issues, it would then be there as an option for a property owner.
We're certainly requiring them to comply with the current ordinance that's on the books now.
Right, so the new one doesn't matter.
Yeah.
So,
There's also going to be a condition a standard condition that we affix to all applications, that when we go out and review the improvements, if we see any situation that's causing adverse impacts to the neighbors, there's a condition in our approvals that says that I can ask them to provide a new grading and drainage plan to mitigate whatever adverse conditions going on. So there is some protection in there for you.
the only other thing is because you can't get it off their prints, what is the true height of the building off of existing grade today?
So.
It's not, there's no way to get it
Let
off the prints.
Mr. Halbruner answer that, but the definition of building height is defined from a referenced elevation within the city. So
Okay.
it's not from the ground.
Okay.
It's from a flood height elevation. So that's probably why you see elevation 11 or
That's
whatever
what-
you
yep,
cited.
Yep.
So we measure no matter what part of town you're at,
So
that horizontal plane.
that's
runs-
ground zero.
That's ground zero for the entire city. So,
Is that from the center of the road?
well, our roads aren't high enough to meet that threshold. Very, very rarely do you run into that, but the definition says you measure from the center line of
Okay,
the
I got
road
you.
or that reference elevation, whichever is higher, and that reference elevation.
Understood.
In almost all instances is higher. Yeah, So,
Okay, I understand now.
what,
Yep, I fully understand.
so that's why you see that
I'm in
elevation.
construction, I fully,
Yeah. So Frog Hollow is low and that elevation.
yeah, no,
is- That's why those houses look like
So,
they're sitting up
so
and.
I thought that may have been true, but then we were misled when we were doing it, so.
Sorry that.
Because we were told that we had to use ground level at our location.
Yeah.
Thank you.
Does that answer any of your questions?
Yes.
Okay, thank you.
Thanks for your comments.
Anyone else within 200 feet, beyond 200 feet?
I'm assuming you can hold it over from the last time I swore to tell the truth, the whole truth, and nothing
No.
but the truth, so help me God.
Okay, good. That's fine. Can you state your name and
Kurt
your
Von
address?
Seacom, here representing 901 Benton Avenue. So, are you guys familiar with Gus Sandy's property behind New York Avenue?
We are very familiar with
Okay.
the property.
So it's my understanding when they were approved to build there, because those houses have two facing roads, that they had to build, in essence, two fronts. Is anybody familiar with that? Yes? Okay. So that is true then, I assume? So, first of all, I'm looking forward to the fact that something would be built there. That's great. There's some new information today that I do have problems with, one of which is the 600 square feet, which is 20 by 30 storage room on was it the second floor or something? Seems a little unusual when you can use the first floor, or since you have extra height, use the attic, go up extra height. But going off of the Gus Andy thing, where you have basically two front roads, it's the same as a corner lot. That's why they do a 20-foot setback on either side, because either one could be considered the front yard. And on the Benton side, correct me if I'm wrong, it's pretty much a flat wall with windows. Is that correct? From what I saw on the plans briefly? So going from 20 feet to 7 feet or 8, if you want to count the overhang as non-existent, but 7 feet, seems like a big ask. I mean, I get the other stuff, 20 feet to 19.25, stuff like that, that seems pretty basic, but it seems like a big ask when you're building a structure that looks like the side of a house rather than the front of a house. There's no architectural detail, it's a wall, basically. And it's from that standpoint, we'll call it unattractive, and doesn't fit the model for what they've had other people do when they have two roads. On 901, I went through a lot of effort to make both sides look, matter of fact, to the point where my neighbors complained that I had two front doors. So I have that. On the positive thing, I can tell you Mr. Hurlis had worked on my drainage plan and stuff like that. That retaining wall and the drainage stuff really works well. So well that in fact, underneath my house, I use for storage. I don't know why you would want to do that. You're elevating it. It stayed dried for me. My drainage system works great, thanks to some of you here, our engineer. So the 600 square feet seems really weird. Personally, I would rather see you apply for a variance for the extra space rather than the setback, but it just seems, I don't know, are there any windows in that 600 square feet?
Yes, there are windows, yes.
Okay. I'm assuming it's not attached to those French doors?
No, the French doors are on the first floor,
Okay.
the second floor.
So I don't know what you'd be storing there that you want to carry upstairs and stuff like that you couldn't store downstairs, or if you are carrying them, you have the extra height, take the height, put it up in the attic. What's the ceiling height of that floor with the storage space?
9 foot.
9 feet.
In the storage room, it reduces the flat ceiling in the living area is 9 feet.
So
As you get to the outer walls,
Would you be
it
willing to put
reduces.
support beams in there that brought that ceiling height of the storage room down to 6.5 feet?
I'm sorry, I didn't understand the question.
Can you make that height 6.5 feet by putting beams in there, so that really?
Not just beams, support beams,
Because then
so they
you
couldn't
do
be
anything.
changed.
Well, you could always add extra lumber to
I'm
reduce
not
headroom.
looking for extra lumber. It would be the type of thing where you would have to probably sink the next floor down and have a sunken room, so that those beams there would be support.
That's a question that cannot be answered without looking at our total redesign.
Well, I know you can do it. I can answer the question. You can do it. The question is, would you be willing to?
Sunken rooms are safety issues to me. People walk, you know, it's so totally, I don't understand what.
So you could put an additional
why you-
false floor up
Why
above.
you not want them to have that storage room?
No, I'd rather have them apply for a variance for the extra space than I would the setback. Go back to the setback at where it belongs. I mean, again, we go to this, and I wasn't even familiar with this hardship variance. The hardship was self-created, despite what you might say, because there was a wall there, and if you kept that wall, you wouldn't need the variance for it. True?
That's not accurate. The hardship's tied to the fact that this is an undersized corner lot. We don't meet the required lot size. That's through no fault of the applicant. It's by no means self-created. He purchased this lot, it was undersized. It's also a corner
the
lot,
wall-
which has two frontages, which is also a hardship, which only corner lots have to deal with in this situation. And we've asked for the variance, and we've provided testimony relative to why we believe that there are unique conditions associated with this lot which justify the variance. This is by definition a hardship. It meets all of the criteria to fall under the C1 variance.
But if you had a structure within, as you claim, I think it was 5 feet or 4 feet or whatever it was, if you didn't change that particular setback there and left what was there, you wouldn't have self-created a hardship.
That's not correct. I disagree with that statement. The hardship is tied to the fact that this is an undersized corner lot. Yes, we could have kept the existing structure that existed there, but the testimony was that it was dilapidated, deteriorated, and it was in such a state that it needed to come down. So we could have kept it, and we could have maintained a 4-foot setback. The building was demolished, the structure was redesigned, and the setback on that front was increased. It's larger than it was.
You're both kind of right, in the sense that you do have a hardship, it's a corner lot, it's a pain to comply with the 2 front yards, but the degree to which you deviate from complying is, I've never really viewed that as a hardship issue, in the sense it's more of a balancing issue, because the hardship is you can't comply with the 25 feet because you would have a 6-foot wide house. But how far you go into that area is to me, is a balancing question. It's not necessarily a hardship. It's not as prohibiting you from building, it's how far are you able to go into it as a result of having that 25-foot, 2 front yard
Yeah,
setback.
and Mr. Halberuner provided testimony.
He provided
relative.
testimony of both. He gave you purposes of zoning, and he gave you both. I'm saying that it's a hardship to have 2 corner lots, okay, to have 2 corner things, but it's not necessarily to mean that it becomes a side yard just because you have 2 corner lots. So it's where you fall on that between a side yard and a front yard setback, where you land that, to me, is a balancing.
And I think it's a combination. Corner lot, 2 20-foot setbacks that are required there, and it's undersized. You look at, those conditions need to be viewed together, and it is an absolute hardship for the applicant in this situation.
I think it's a factor in the balancing, but we'll call it whatever you want.
Sure.
We'll do both.
I'm not saying that now it isn't a hardship. I'm saying that if the wall was still there, you wouldn't need the variance for it, and it wouldn't be
That part
a
of it,
hardship.
that's okay.
So that's all. But my main objection is the visual of just a big flat wall at 5 feet off, 5-foot setback. It just seems like some kind of architectural something would be helpful. The rest is, and the 600 square feet, there's something that's a little bit too weird when you have so many other options. You have the underneath of the house, which I don't know what the square footage of that is, but if you're elevating the property 18 inches or whatever it is, how much drier are you going to get? If we get that much water, there's a bigger problem in Cape May than worrying about what you had stored there. Unless you're storing some kind of rare, unusual materials. What are the plans for storage? What would you store there?
What do you store in your attic? The same type of items?
I don't have an attic. I don't have a storage attic. I have no access to my attic.
Major points.
We're trying not to do a debate thing, we just kind
Yeah,
of like.
it's
you say your
10:30.
thing
Can we kind of wrap this up? Anyone else that would like to testify? No? All right, seeing none, we'll close it to the public at this time.
Can I have an opportunity to, just briefly, I just want to touch on some
You can
points.
make argument, just no new testimony.
No new testimony.
Go ahead.
So my client provided testimony relative to why this storage area is proposed. Now, the testimony was that the ground floor, he's concerned about flooding. You know, you're allowed to have storage space in a house. This comes up oftentimes when people throw dens or home offices in, it's going to be another bedroom. It's his testimony before this board that that will be storage space, akin to an attic, essentially. And to take that a step further, we've proposed a condition of approval. We're agreeable to a deed notice. There are provisions in the ordinance and safeguards to ensure that that space is not converted, and if it is, this individual is going to face a summons and is going to have to ask for that in court. Now, with respect to what existed, we did provide a survey which depicted the structure that previously existed on this property. It does in fact show a 4-foot setback on Benton Avenue, and it shows an approximate 4-foot setback on Jefferson Street. Granted, the face of the structure was significantly set back from that 4 feet. What's been proposed by the applicant and what's been testified to by Mr. Halbruner tonight, there can be no question that those setbacks are being increased compared to what previously existed. We do require variances. There's no question about it. We're upfront about that, and the biggest variance here is obviously the Benton Avenue setback. But I think the mere fact that there are requirements to comply with 2 20-foot building setbacks does create a hardship, coupled with the fact that this is an undersized lot. It presents practical difficulties with complying with the ordinance. Could the applicant construct a structure that fully complies with the setbacks? Probably. Would that structure be usable by this family? Would it meet their needs? No, it absolutely wouldn't. It would basically zone this property undevelopable for this applicant. Now, with respect to the parking, I think it was Mr. Dorman who indicated that we're going to lose an off-street parking space. We are going to lose an on-street parking space in this situation. There's an 18-foot curb cut proposed. That's 1 parking space. What are we gaining? We're gaining 4 off-street parking spaces where no off-street parking previously existed. We had a 5-bedroom house that existed on this site with no parking. We now have a 3-bedroom structure that's proposed by Mr. Schultz with 4 off-street parking spaces. In my experience, more parking is always a positive, especially in a shore community. I mean, this board, I'm sure, hears it in multiple applications that come before you on a monthly basis. Parking is a problem, and the ability to provide more parking and to reduce the density of the site is a positive in this situation. With respect to the drainage issues, I don't know that much more needs to be said on that front. You know, there's a retaining wall that's put in place. The city has an ordinance that regulates stormwater management. Your engineer is going to review the plan to ensure compliance, and it sounds like the city's in the process of adopting an ordinance which will put further teeth into that situation in the event there is runoff that impacts a neighboring property. It's not going to happen in this situation because the plans that have been submitted will confirm that the water will be directed to the street. And with respect to the storage area, and I don't want to belabor a dead point, but I think the deed notice or the deed restriction, which we are amenable to, as well as a condition of approval, provides assurances to this board that that room will not be converted to habitable space. And if it is, there are recourse and repercussions which the applicant would face. With respect to the ground floor, I mean, sure, we could store stuff down there, but my client's already expressed concerns relative to flooding. I mean, just because we're raising the property up doesn't mean that flooding's not going to be a problem. I mean, where do you store your valuables? You're going to want to store them. You're going to want to store them in a location which is safe, which is protected, which isn't open to the elements. And I know this area is going to be enclosed, but my client, this is going to be a second home, and storing something in a vacant void ground space area as opposed to the interior of the structure, doesn't really meet his needs, and it doesn't provide the level of security that I think any homeowner would want in that situation. And I know in this situation, the applicant has come before this board and he's asking for relief, but this is the Zoning Board of Adjustment. You have the power to grant variance relief to an applicant when they provide a basis to justify that relief. There's been adequate testimony to support the fact that there is a hardship in this situation. There's also been testimony provided by Mr. Halbruner relative to the C2 criteria. There are a number of purposes of zoning. I think I counted 4 which are advanced in connection with this application. Promotes the free flow of traffic. Maintains and promotes light, air, and open space. It's a desirable visual environment. What's the 4th one I'm forgetting here? Promotes flooding. Flooding, apologize. It's been a long night. And we testified to the negative criteria in this situation. You know, Mr. Halbruner identified the fact that there are a number of positive elements to this project which will exist, which don't exist now. So for those reasons and for the testimony that was presented, we believe that there is a sufficient basis for this board to grant the C variance relief requested by this applicant tonight. And we hope that we've met our burden, and we hope you see it that way. We do thank you for your time. It's been a late night, and with that said, I rest.
Thank you.
Sorry.
I can tell they turned the heat down. Lights are off.
Any discussion?
Any more discussion? Anybody?
The motion I recommend being made is a motion in the, oh, I should talk about the standard. So they've requested a variance into the C1 standard, which we just talked about extensively in our last application. There's also testimony that could support a C2 variance, which is the balancing. So I'm going to ask you to consider both of those standards. Where's the microphone, police? Sleeping over there. You didn't yell at me for the microphone. I finally wore you down after 4.5 hours. Okay, so the hardship variance is the, under the C1 and C2 standards. Now, I've said that the motion that I'd recommend being made is to grant the application, but that doesn't mean I'm suggesting that you grant or deny it. It's just that we always make the motion in the positive, so that we know that if we vote yes, it's approved. If we vote no, then it's not approved, but I'm not implying you should vote either way. So the motion that I would recommend being made is a motion to grant the variances listed on page 1 through 5 of the engineer's report, subject to the conditions outlined 1 through 15, including a deed restriction for any storage space. And that's the motion that I recommend being made, but again, that's not, I'm not recommending you vote yes, I'm just you vote however you want to vote. Okay? Anybody have any questions?
Somebody make the motion.
So moved.
Second.
Thank you. Motion by Mr. Ledwin, seconded by Mrs. Notch. Mrs. Werner?
Yes.
Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Mr. Walsh?
Yes.
Mrs. McDade?
Yes.
Mr. Murray?
Yes.
Mrs. Hutchinson?
Yes.
Thank you. All right, do we have a motion to adjourn?
So moved.
Thank you, all in favor?
Yay. Yeah.
Thank you, everyone. Good night.